Check. Not recording already. It's October 11th, 7:30 in the morning. What up? I got you.
Alright. Okay, I'm getting close to the office, so I'm gonna walk in and I'll have you on speaker.
Okay.
Can you hear me okay?
Yep, and I'm recording.
What's that?
What's that?
What'd you say?
Oh, I said I'm recording.
Okay, good. Alright, I'm going into the office now, thank you.
Okay.
Yeah, I don't think you hear yet. I'm gonna send you a text message to see if you get it.
You're gonna do what?
I'm gonna send you a text message to see if you get it.
Oh, okay.
We're waiting for him.
Okay.
Looks like he's not here.
It's actually kind of good news if he's late. He might be running late and unprepared.
Yep.
And the second he gives you the tiniest bit of shit, you can always come back with this. You know, like...
Yep.
So much.
Yeah, it'll be a good idea.
I'm gonna talk like I'm recording this for statists, damn it. Columbo, I got this.
Did you get the text?
Yes, it says test.
Okay, good.
If you want to draw my attention to the fact that you sent a text, then use the phrase, go ahead and then do something. You know, some people say, oh, we're going to have to go ahead and blah, blah, blah. You can use that anywhere. So I may not, it doesn't beep at me like, beep, you got a text. It just puts a message or a symbol on my phone. But it's hard to, you know, it's small. So that'll be like the secret to look at my text. We're going to have to go ahead and... Okay.
Deal.
And I'll do the same if I send a text to you.
Excellent.
Do you want to give up the goals if he asks ahead of time or up front, or save those till the end? The subpoenas and the extra meeting to go over all the recording and whatnot.
Yeah, I would kind of lay it out early if given the opportunity.
Okay. I'll just let you do the intro and then say hello, how are you, blah blah blah, nice to meet you, and then let you kind of start it and work myself in.
Yeah. This is a strange office. It looks like when I look through the door, it looks like it just leads up into the stairwell, but I think maybe I just can't be inside or something strange, like government contract stuff.
Yeah. Yeah, I'm assuming he's going to ask all kinds of questions that are just not relevant at all. If he's got short on patience and he's already been insulting you, I'm looking for more of that. You know, he might not have the time for this. He's got a busy day and he just wants to say some stuff for 15 minutes, like we said.
Yeah. I think it'll be kind of fun.
Yeah. For sure it's that.
Oh, well, yeah. I have to do all. Yeah. I had a picture during How well could you hear those people? Pretty well.
I can hear that they're talking, but not really make out what they're saying.
Okay.
I'm just going to tell him I'm a friend. That's all that needs to be said.
Jail assistance of counsel.
Yeah, we could do that. Well, how come this is the first word I'm hearing of him? Because they won't let him in as my assistants of counsel. They only let in people who are there in person and members of your state bar.
Yeah, exactly. And that's one thing that I want to show for sure.
Yeah.
I forgot to say that, I guess, but that's something that we need to show for sure, because I've been trying to ask about assistance of counsel, and I haven't wanted to waive my right.
Right, exactly.
You know, so
exactly.
If you're familiar with basically 15 minutes to sign this document or I go to jail, and that was the waiver of counsel, right? You remember that?
Yeah, yeah. And that is one of the worst crimes they committed against you. That moment where they're like, you've got 15 minutes. Or you're going to the cage. That was so telling right there. We got to put a spotlight right up that ass.
Sure.
So everything's an opportunity to point to how they've used threats of violence to get us to this point, instead of reason and maxims of law.
Yep. I'm sending, I don't know if it'll send or not, but I'm trying to send you a picture, and I'm just curious if it sends while I'm on the phone with you.
There's this part in Lysander Spinner's book where he mentions that back in the day, around his day, they were so concerned with the legitimacy of signatures in contracts that when a married couple came in to sign something, they would have the wife, as part of it, go in a separate room and be questioned to make sure that she's not signing this under any coercion or duress from her husband.
Wow.
Can you imagine how, like, you know, That's like going to a lot of lengths to make sure. And now today they not only deny it, but they force us to claim that we're not when we are.
Yeah, they've completely made it like a small, meaningless thing. Like, you're saying, oh, just sign here, just sign here.
Yeah. And it's the biggest of things. That's what they're doing for me, too. Even when I was at the end of my drug war charge and getting rid of that the last hearing or two, they were just like, oh, well, what about this? Would you, my, quote-unquote, the lawyer that they tried to force on me, his last words to me were like, well, what about this? Would you sign this? What about this? Would you sign this? This just says what you want. Do you want to sign this? They just wanted me to sign anything, even though it was, like, looked really non-binding. I was just like, if they want it, I don't. They want me to legitimize this process as a court when I've basically been treating it like a kangaroo court.
It's really late.
Yeah. Same thing with delivering it. Assuming it's sealed correctly, delivering it was just another step like signing it. And if you signed something but you didn't want to deliver it, you were every bit as free to just tear it up. So it has to be signed, sealed, and delivered, hence the saying. You know that song, signed, sealed, delivered, I'm yours. Holy shit, that's where it comes from. We should do a parody video of that. Here it is, babe, signed, sealed, delivered, like jurisdiction or signature.
I think I hear his voice.
Okay. Game time.
He sounds kind of like the architect on the Matrix.
They probably have that as an advanced course at Harvard before graduation. Intimidating personas to adapt, like WWE wrestlers.
Oh, were you able to get the picture I sent?
Oh.
I was curious to see if it.
Let me check. It's not showing anything coming through yet, as far as via text.
So it probably won't send until after I hang up.
Oh, yeah.
Picture of the board.
That's cool. It sounds like it's in the queue, though.
Yep.
Yeah, if you can get any pictures of anything in there, they might get used for the cover.
Yeah, thanks for helping with this today.
You know, it's my pleasure. So that's like, who wants to go on a sabotage sortie to go hurt the government over a simple phone call? I'm raising my hand. Yeah, I'll do that. I'd do one of those every single day if I could. Just wake up in the morning and that'd be awesome.
This is a form of intimidation too, to show up really late.
Yeah. The one who is being waited on is like the position of power. The one doing the waiting is like disempowered. So pathetic. Psychological BS. I mean, at what point are we gonna get up and leave? You know? If he doesn't show at the hour in 18 minutes. Like, holy smokes. First he canceled, or first he delayed, and then he just didn't show for half an hour. I got things to do.
Yep.
You could put that in emotion, too. I wonder if it would be interesting to have a YouTube channel up by the time your next hearing came up, because it's so far away, and because it would just have, like, tiniest snippets of the, like, you know, like a 10-second clip or whatever of the most heinous instances of their abuse of power, you know?
Yep.
Could always be used as a tool or a weapon in that hearing, like, oh, just go to this, check this out. I've compiled it so easy for you to digest in your chambers, it's not even funny. Anybody with a cell phone connection can look it up, go to channel blankety blank, and everybody in the courtroom can go there too. See what you're talking about. So they can all hear it, regardless of whatever the judge wants or will interrupt. Anyway, back to game time.
Oh, I have my dad, he, a long time ago, bought the domain name, like a website domain name, because he thought that one day it could be used to show, like, bad things the government does.
Really? Your dad?
Yeah. So he owns CanYouHearUsNow.com.
Oh, sweet.
So if we ever figure out something that we can do with that, like the whole idea was, can you hear us now?
Yeah.
We're the voice, that hasn't been heard in so long.
Yeah. You know what? I've got so many videos in my head that I could make, but I'm just like, no. But one of them that might actually come out soon is, it's going to be titled, like, 25 Ways to Simply and Effectively Overthrow the United States Federal Government. You know?
I wonder how long before that gets taken down from YouTube.
Do you think they would take it down? Just for that?
I don't know.
Because I'm going to assume, like, I have $1 million and I'm speaking to millionaires. I'd be like, you could do this, you could do this, you could do this. Just plain and simple, no emotion to it at all, but it's going to be like the most vicious. I can't wait till it comes out. I don't know, it'll be pretty funny. Has this guy had any idea how good we are at waiting?
Waiting game. I wonder what his excuse will be.
God only knows. Besides bullshit, you mean?
Mm-hmm.
Yeah. It's now 47 minutes past the hour. We had scheduled to meet on the hour, and then he called and delayed till half past the hour. Now it's 47 past, still waiting. October 11th.
Yeah, good thing a judges appoint these attorneys who are so good.
Yeah. I wonder if he thought of it as a judge-ordered meeting, if he would have showed up if there was any consequence to being late.
Yeah.
I mean, this isn't just out of his schedule, right? This is ordered by a judge. You wanted it moved to something agreeable. You both agreed on Tuesday at 10.
Yep.
Mr. Harvard, that would be one good question. So you mentioned before that you had been to Harvard and 20 plus years of experience. Can you inform me as to why the judge thinks it's necessary to not only put a legal advisor and force this meeting in order for me to dodge the trial and that inevitable conclusion, but over a case that is so inconsequential that the plea bargain is 8 hours of community service? Why is such a heavy hitter like you even bothering with such a little case like this? That would be a really good question, because it points, it forces him to, because that doesn't make any sense at all unless you're very powerful. So it forces him to address why they consider you powerful. So I don't think he'll do it, Oh, that's just the way it happens sometimes. I donate and volunteer X number of hours per week, and lucky you, this was your hours of volunteer service for me.
Yeah. Yeah, that would be a good one.
How many other times in those 20 years has someone challenged jurisdiction? That's a good question.
Yeah. At least in this manner.
Yeah.
I'm sure that there are some challenges by government authorities or corporations.
And if he starts to pull the whole, because obviously I've heard a few of these, talks with lawyers in side rooms, and if he starts to go in about how this is all whatever, improper, unusual, or this is just not how it's done, you don't have a choice type of thing. You could always go, they often do, I don't understand that, this is nonsensical. You could just go ahead and bring up Socrates himself. He's like, you're familiar with Socrates and the Socratic method of investigation. Because if you're calling what I'm doing nonsensical, then at this point of the game, that's what I'm doing, and that's what you're calling nonsensical. I'm simply clarifying the allegations of the various parties in this court. I'm not even making my own assertions about anything. So that would be a good way to shoot down. I don't know, I'm just talking out loud while we're waiting. Because I know it's coming.
Like if he tries to say it's all nonsense and stuff.
Yeah.
That's one thing that he's definitely going to do.
Oh, yeah. So it's nonsense to ask a prosecutor or a judge to clarify something that they're saying is accusing me or binding me to something. That's nonsense. To have them clarified because it's intentionally kept vague. I wouldn't mind, if Socrates, as the word, came out. Because, then it's like putting on the table that his Harvard in 20 years doesn't mean shit. Because, the violations are so blatant, it's so easy to address and discuss and confront. It doesn't take 20 years in Harvard. Not even close. Any attempt to put up some illusion that it does will be seen as such, and predictably boring and kind of like a weak tactic, honestly. You don't have any better tactics than that in 20 years of Harvard and Harvard. Let's be honest, we see level 1 judges in traffic court pulling that.
Now, you had a legal advisor, didn't you, for a while?
No, they said they never tried that without also putting him as my representation officially on the record, despite my objection and promises that they wouldn't.
Oh, wow. Okay.
Yeah, so I never had one of these before. They were always fraudulently put on as my representation.
God. And you ended up getting him sanctioned, didn't you?
The first one I got sanctioned. The second one I just got humiliated and embarrassed. And the third one I pretty much fired via pointing out to the judge's own bullshit and how he couldn't be on my case. So it kind of agreed with me and ended up, like, he ended up being dismissed in the middle of a hearing, leaving my side and leaving the courtroom because he was no longer part of it.
Yeah.
He was only 2% of people here are black. He was a black guy, and he was super slick willy lawyer. It was pretty funny. All trying to be nice and smiles.
I think what I'm going to do is try to call him and see if he answers and see where he's at.
Yeah, and tell him, I can meet you up until 8 o'clock. That's within 5 minutes to start this. I have other appointments I have to get to, and I'm sure the judge wasn't anticipating, us meeting an hour after the proposed start time.
Yeah.
Put it on him.
Okay.
I'll talk to you soon.
Yep.
There is zero reason to be intimidated by any of them. I mean, if you're going to be intimidated just because it's a new environment, and a new room, and a new thing, that's one thing. What up with it?
Hey, he just got here.
Oh, okay.
Gotta come back out there if you want to keep it on. I guess you can't. How's your day? Kept kicking behind the ball. Yeah. Train was running slow today, and that was not to me, Jeff. I'm sure nothing else. So I didn't have time to. I'm on with Joe. He's my assistant counsel. I don't know what that means. You mean a non-lawyer practicing law? Is the way I look at it. Assistant counsel is what he is. Well, it sounds like a non-lawyer practicing. Well, is that what's on the phone? Yeah. Okay. Well, we'll have to wait until he's on.
I'm on the phone now. Hello. Good morning.
Go ahead, Jeff.
Good morning. I'm Joe.
Yeah. Right. That's great.
Okay, so let's proceed then.
What's that?
Okay, so let's proceed then.
No, we're not gonna be able to do that. I can't have a conference with somebody that's not, part of the defense team. No, not at all. I presume you're not a lawyer.
You can presume whatever you need to presume so that there's no kind of conflict of interest.
Are you in fact an attorney licensed to practice law in the state of Oregon?
Sir, I'm under no obligation to answer any of your questions. I'm here as Robbie's assistant.
I think that is a no, and I'm under no obligation to sit here with some non-lawyer practicing law in my office. So,
well, you can take that as a no, but it might not be a no for all you know. So I'd appreciate it if you extended me the professionalism I'm extending you, and try not to Sir, I'd appreciate it if you'd not interrupt me. We have communications over long distances, and it helps our communication.
I'm not allowed to defend myself? You're not allowed to have a lawyer on the phone while I am.
Do you have any evidence of that? Do you have any evidence of that claim, sir?
Well, that may be, but I'm not his legal advisor, nor is he yours. Well, he's my assistant counsel. No. The only reason I haven't been able to have him in court is because of he's not a lawyer. Well, no, that's not why. Because he's my assistant counsel. So, in order for us to work together, we are the defense team, and this is the three of us working. No, it's not the three of us, I assure you. You're refusing to do your job? No, I'm insisting on doing my job. Okay, so let's do the job then, and let's prepare for that. Well, he's not going away. He's my assistant counsel. Well, why don't you explain to me what you think you're doing in your defense? I'll advise you. I will take the advisor role in the most passive sense possible, since I cannot actively assist you while you have a non-attorney on the phone.
We're not acknowledging or denying any of that, but we would like you to obviously maintain this lowest assistance possible. After all, this is a meeting forced by a judge, and the only other option was to, be forced into a trial and the inevitable conclusion and punishment that entails. So,
well, which will be inevitable in any event. There will be a trial.
So,
unless Mr. Esterbrook determines to enter a change of plea.
So you are saying that it's inevitable that there will be a trial, even though you're not even officially a part of any litigant in this ordeal. Is that correct?
What I'm saying is that the state has filed charges. They've indicated no willingness to dismiss those charges. So as far as I can tell, there will either be a trial or there will be a change of plea. I don't anticipate a change of plea.
Well, yes.
There needs to be a plea in the first place. A plea is not guilty. It's already been entered. It hasn't. I've not entered a plea. Fine. But you are facing charges, and whether or not you choose to enter a plea, the court will enter a plea of not guilty on your behalf because you're presumed to be innocent.
How is it that you come to the knowledge of knowing what the court will force, regardless of Robbie's intentions?
24 years of experience would be my first answer.
Oh, okay. So the fact that you've been in for 20...
Why don't you tell me Mr. Esterbrook, why don't you go ahead and talk?
Well, you mentioned 20 years as the reason why you would know a court would do something, and I'm suggesting that whether it's 2 years or 200 years, that's no reason to claim to know why a court will act in the future, sir. How is it that you know the certainty of what you speak? It almost sounds inevitable.
But why don't you speak for yourself for once? What is it? Well, this is my assistant counsel. What does that mean? He's the one. What do you mean? What does that mean? What does that mean? You know what an attorney counsel is? No, I know that you have a right to represent yourself, and in the alternative, you have a right to be represented by an attorney.
Sir, your rights are your own statements.
Right to be represented by a non-attorney. Can you explain why you believe that there's no right to be? I'm not trying to explain. I'm not asking. Well, I'm not asking for representation. Stop interrupting. It's very unprofessional. All right, is this what Harvard taught you? Okay. So my assistant of counsel is here to assist me with my defense because I'm being forced by this court into a trial situation when all I've been attempting to do is enter a plea of guilty. All I've been trying to do for 10 hearings is enter a plea of guilty. Well, it shouldn't be difficult. Well, it shouldn't be difficult. It's sad. How come the court is wanting me to perjure myself in order to enter a guilty plea? Could you elaborate on that, please? Well, I still have clarifications on the table to where I need to be informed of the cause and nature of these proceedings. I still have questions on the table that have not yet been answered, and in fact, the judges and prosecutors have been committing criminal activity in order to conspire against me to conceal information from me. And so I'm only meeting with you right now because you are the legal advisor appointed to this case. You are appointed under threat of violence, because if I didn't take you, then I would have been forced into a trial setting on Monday when I was never, ever prepared for trial at all. I still have cross issues. But one of those issues is, has the prosecutor submitted evidence establishing jurisdiction for the court to impose upon me? I need a yes or no from the prosecutor. And another clarification that I have is concerning the penalties. I have clarifications on the table regarding the possible penalties, and the judge refused to inform me of that nature of these proceedings. So, as far as I'm concerned, my assistant of counsel may speak as me right now. He is not representing me in a court of law. We are merely a defense team, and he is the one who is helping me right now.
We use the word help in this context. So, my question would be to you, under what legal authority do you believe that you have this right to require the state somehow to make an explicit statement of jurisdiction? What's your source of that?
How's that relevant?
No, because you just said it. You just said that the state hadn't done these certain things. I don't want to mischaracterize the words you use, and I didn't record them. But
Sir,
you said that had not, pardon me, you said that the state had not, correct me on the wording, but you made reference to establishment of jurisdiction. Am I wrong about that?
Has the prosecutor submitted evidence establishing jurisdiction for the court to impose upon me?
Right, and the question was, under what authority do you believe the state's required to do that?
That's not the question.
Yeah, it's a question I just asked.
I don't have a problem answering that.
Why do you think they have? I'm asking you simply why you think they have to do that.
Go ahead, Joe.
The answer is, we are not asking the court to do anything. We are asking the prosecution if they have submitted a document to the court, yes or no. Now, that information of whether something has been submitted has been denied. Okay, we're not making any claims or assertions as far as this authority is what we point to make the court do something. The court has the guns and the tasers. We're well aware we can't make them do anything other than the judge's opinions and will. So we're not trying to. We're trying to find out if we have the right to be informed whether or not the prosecution has submitted a document to the court. In this instance, it's evidence of jurisdiction.
Okay, and you say you have this right. So my question was...
I did not say that.
You said, we have the right, and again, I'm sorry I'm not recording, so I can play it back to you, but your sentence began with, we have the right.
Okay, let me clarify that. We would like to know whether you, the court, and all of you, respect your own, what you claim is a right to be informed of the cause and nature of the cause and nature of the charges and proceedings against us, right? Straight up out of your Bill of Rights, right? So that's what is going on here. We don't even use rights, okay? We don't use the Constitution. I'm not claiming any of the rights. The only rights that I'm talking about are the ones that the state hypocritically violates. And because sometimes they coincidentally line up with ethics, then we will mention them. But yes, we would like the right to be informed of the cause and nature, but we're not saying, oh, we have this, give it to us. We're saying, you guys say we have it. Please do it. We'd like to know whether this document has been submitted by the prosecution.
Okay, well, I'm looking at what appears to be an information of district attorney signed by a deputy district attorney, Jenna Plank, with her bar number and the bar number of the district attorney of Multnomah County, stating, in fact, what the cause and nature of the proceedings is, which is one count of interfering with the peace, parole, or probation officer, and one count of criminal trespass in the second degree. The elements of those charges are set forth in the charging instrument. That constitutes, in fact, the constitutionally required information as to the cause and nature of the proceedings. So I'm not sure what else you're looking for.
Sir, the statement that you just made, we could challenge several different words in there that you're attempting to use as an explanation.
Give me a moment, Joe. Yes, hold on. Stay with. Hold on.
Okay.
Yeah, I've got a client with me, but what's that? Okay, if you've been in good contact with me, I will see if I can reach him and let him know. Thanks. Okay, my apologies.
No problem.
I don't have any staff here to assist me. And unlike Mr. Estabrook, I don't have staff to assist me.
Well, you've apparently been to Harvard and you have 20 years of experience, so I doubt you need it on a case that was, offered a plea deal of 8 hours of community service. This isn't that serious. It doesn't require much. We're just requiring to be informed. And further, sir, I'd like to make one last point before I am interrupted, and that is that we know that you're well aware that the phrase cause and nature, to be informed, includes far more than what you just referenced. What you said was a tactic common that judges use to try and fool, defendants, quote unquote, that's all that includes, when obviously it doesn't. And that obviously is by judges much higher pay grade than the judges in that county. This issue of the right to be informed and the cause and nature, the definition of the cause and nature, has been something that's been bantered about for decades and decades and decades. So we're not going to be satisfied by your one opinion of it here today.
Well, then why don't you share with me some other source for opinions? That's all I've been attempting to do here, is to inquire as to the source of these legal principles that you seem to be offering to me.
Does it matter if I'm in, well, I don't think we're talking about legal principles.
We're in court. What are we talking about?
I'm just wondering, does it matter whether or not I'm informed of the cause and nature of the proceeding?
Well, of course, the Constitution requires it. And what I'm saying is that it appears to me you have been, and you seem to be disputing that fact. And so, if you allow me to finish. So all I'm asking you to do is, since I have this idea as to what being informed of the cause and nature of proceedings against you means, which is the charge against you, and since you appear to have a different idea, or to at least reject the idea which I'm operating under, which is that this in fact does so, what I'm asking you to do is tell me, if this isn't, then what does, and why do you think so?
Sir.
That's all I'm asking.
Okay.
I'm trying to get to the bottom of this process.
So I have a question for you. If I say, in order to defend yourself in this game that we are about to play, that I'm going to force you to play, you have the right to be informed of the book War and Peace. However, I'm going to read you the Cliff Notes version, and now consider you informed of everything that is necessary that you need to know about that book. If you don't, is that actually informing you? No. It's giving you a summary, but it's not answering your clarification questions. It's not letting you actually be informed. So I'm not looking for some judge to say, oh, I've informed you because I've read this summary of charges. I have clarification questions on the table that are crux to the issue before I even make the decision on whether or not to have an attorney. I'm still trying to go through arraignment.
Right. And I've seen that on 2 occasions. I've seen you.
And I am trying to go through your arraignment process, which are, well,
I mean,
are you a member of the court?
Well, it's mine in the sense that I'm a citizen of the United States, a citizen of the state of Oregon.
You're a member of the court.
And a member of this, community.
So who do you represent?
Who do I represent? I don't represent anybody, because I'm not your attorney.
Then why would a judge force, under penalty of violence, Robbie to meet with somebody who is not represented by anybody? Who are you here?
I am a legal advisor to Mr. Estabrook. I am here to give him advice, to assist him in his self-defense of these charges.
And why would a judge force somebody who doesn't represent anyone?
Well, I don't represent anyone in the sense that I'm not the attorney of record. At Mr. Estabrook's request, I am not the attorney of record.
Why did the judge choose you?
Pardon?
Why did the judge choose you?
Well, a couple reasons. One is, by coincidence, I happened to be the pickup attorney that day who was taking the conflict cases, which other lawyers were conflicting out on. A second reason is my fairly extensive experience and credentials as, and it would be somewhat immodest of me to say that really one of the more experienced and better criminal defense attorneys in the area. And third, because I have a niche practice of dealing with the most difficult and contentious individuals.
Why would they put you on this case if you deal with the most difficult and contentious individuals, when we've been fairly simple and just asking for whether or not the prosecution has submitted a document? There's nothing contentious about that, sir.
You're even being contentious about how contentious Mr. Estabrook has been in court. I can assure you, after nearly a quarter century of experience, that there are only a handful of individuals who have reached to that level. I have represented a number of them.
Okay.
Individuals who have these are fairly common themes. This isn't the first time I've heard this stuff. It has, to the best of my knowledge, and I think it's fairly extensive, none of these arguments have ever had any success in court. They are, if you'll forgive me for being blunt, delusional. And in addition, the circular manner in which you respond to my very direct questions, and my questions are always, what is the source for your assertion of belief?
Mr. Taylor.
Tell me where you got that idea.
Okay.
Because I am operating under what I think is a very safe assumption, which is that you didn't just concoct this stuff yourself. You got it from somebody else.
Okay.
And so what I'm asking you to do is tell me who or what is the source of these ideas you have about what is required of the court in terms of notifying of cause of nature. I mean, these statements that both of you seem to be making about the requirement of the state in the form of the prosecutor to somehow make a statement establishing jurisdiction, and then the remarkable quibbles about whether I have somehow parroted back your issues in precisely the same language such that you can divert from simply answering the question. This practice, this mode of thought, which I previously described as a mind-numbing miasma of sophistry and stupidity, is not the least bit original. And so what's interesting to me is to try to find out what seems to be a person of relatively goodwill outside of his delusional beliefs in the court system, and that includes Mr. Brook. Why, in fact, he has been hooked into this delusional fringe thing. And so I'm just curious to know how he got himself in this position of thinking.
Okay.
Well, I need to know a little bit more about Mr. Estabrook, about his academic career, his history, how he did in school, any features of his life experience that might have brought him to this point.
So what I'm curious about is facts matter or not.
Well, that's kind of a I mean, that's kind of a silly question. But
if you want to relevant facts, I'm talking about legal
relevant facts matter.
Yeah. Well, you keep on talking about like legal opinions and the legal authorities and all of that, but we know that that's just made up entirely of opinion. So I'm asking about factual evidence. So all I'm asking for, because I don't believe in your religion. I don't believe in this Bible here. I don't believe in the rituals that are conducted in the courtroom. So I'm a person and I have no idea why I'm being attacked by you guys. I have no idea being attacked by me. I mean, I'm a member of the court.
I'm an officer of the court, but I'm not an officer of the court whose function is to file charges or to enforce the law. My function is as to act as a limiter of the state's power by assuring that individuals represented by me are afforded due process of law.
So why due process?
Well, that's your opinion, and I'm trying to get a little bit more comprehension of why you have that.
Okay, Mr. Taylor, I'd like to interject here and try and maybe refocus our efforts here. Our time is valuable. We've already been delayed coming to this. Again, as Robbie mentioned, we'd only like to stick to relevant issues of fact and not opinion. You can just assume that we know all of the basics about the law. You don't have to explain to us what your job isn't. I mean, we're pretty familiar with what's going on here. Your smoking gun question to us is, upon which authority are you guys using, or where does this come from? I mean, as if that would lead to something relevant from your point of view that would preclude us from getting this piece of evidence that we're looking for. I mean, lastly, I know you're aware of what logical fallacies are as part of your professional training, and we both appreciate the professional courtesy of you not engaging them. Please, if possible, especially the one you tend to use of, oh, something's been happening for a very long period of time, therefore, because of that length of time, this thing is now relevant. You have to win an issue on the facts on the table, issues of law, not just opinion. And so please, we'd ask you to proceed in that direction. Please stop attempting to distract, to spend these precious minutes off on things that are not relevant. We have issues that we'd like to address here. We've addressed them. You're not responding to them at all while saying that we are the ones who are not responding. We're simply asking, and I'll do it for the third time. The prosecution has not submitted evidence of jurisdiction. Unless they have, the only reasonable, logical conclusion is that they don't have it. If they don't have it, then they don't have the right to impose, and yet they pretend they do. The judge is in on it, and it's all biased toward the prosecutor. Now, please stop speaking to us as if we don't know what's going on here, big picture. We're fully aware. Okay, so let's use our time wisely. Without using logical fallacies, we don't need to know the authority that the authority that we rely on is logic and ethics. Just leave it at that.
Okay.
That has a prosecutor submitted evidence of jurisdiction. Why won't you help us toward that goal?
Why won't you just help us get an answer? Okay, well, what I'm going to do is I'm going to apply the same standard to you that you appear to be applying to me, which is the avoidance of logical fallacies. So the syllogism that begins, the prosecution has not submitted evidence of jurisdiction. Therefore, the only logical reason is that they do not have evidence of jurisdiction. It is, in fact, a logical fallacy because it presumes an additional proposition which you did not state, but which you presume. That additional unstated proposition is the prosecution is required to submit evidence of jurisdiction. Because the prosecution is not required to produce evidence of jurisdiction, then of course the fact that they had not done so would not necessarily lead to the conclusion that they simply lacked that evidence. And so that's why I asked why it is you believe they're required to do so. Because again, I was addressing the unstated assumption, the unstated premise of your syllogism. So if you want to play logic games with me, if you want to address logical fallacies, I'm happy to do so with you. I think
I'm sure you are. There's nothing games about logic, sir.
I'm going to repeat my question. On what basis do you derive the premise that the prosecution is required to establish jurisdiction for an individual whose body is in the state of Oregon?
Sir, I responded to this once before very clearly. I'll do so again and attempt to make it even more clear. We are not saying that, hey, the prosecution, we require that they do this, we need to force them to do this, they are obligated. Okay, they may have jurisdiction. We don't know. They may have it. We'd like to see evidence of it to see if they do or don't. Now, if they don't, over the course of 10 hearings and almost a year, one could conclude that they don't. Obviously, it behooves them to produce it, to shut Robbie up, and to move this thing along. He's been through not one, but 2 courthouses, several judges, and several prosecutors, and not a one has been able to get him past arraignment, despite all their power and the guns and the tasers, and possibly Harvard and X amount of years of experience. So if that's the case, why can't they get such a simple matter past arraignment? He even goes to a judge and says, no, this isn't arraignment. And so then the judge goes, okay, well then how do you plead? Agreeing that here we are at arraignment still. So please don't come to us with these inconsequential distractions like, oh, what do you rely on? And if you want to talk logical fallacy, you're a lawyer, with all due respect, sir. We go to court and lawyers use a great deal of logical fallacies. I'm not going to sit here and argue with you what is and is not. Okay, I'll let whoever, hears any of this proceeding be the judge of that, public or court. But I would just like to stay on the same playing field of where is this evidence. Go ahead.
Yeah, and I'm not saying what the prosecutor has to do or doesn't have to do. I'm simply asking a question so that it'll satisfy me, a part of me being informed of the cause of these proceedings. Has the prosecutor submitted evidence establishing jurisdiction for the court to impose upon me? Yes or no? All I need is the yes or no. That's one clarification. But everyone, every judge, every prosecutor has refused to address and to pretend to answer it. They threaten me with violence when I ask it. And so why? Why won't they just give me a simple answer?
And please don't say that they don't have to. No, that's not. Please don't say they don't have to, because the judges say they do. Thank you.
Okay, well,
the term cause and nature of the proceedings includes a statement of jurisdiction. Because otherwise, why would they have to say? That's what I'm hearing you say. What? When you say that all you're doing is you're inquiring as to the cause and nature of the proceedings, when you insist that there's some statement regarding jurisdiction, then you're assuming that jurisdiction is somehow...
We're not assuming anything. We're not claiming anything. We understand that the way you attack is that you force us to make a claim or position and then attack it. We're not. Do you understand that we're relying on the standards of the court, sir? If you're going to attack what we're saying, then attack the rules of the court itself.
No, I'm attempting to understand what you're saying because you're saying certain things. Mr. Essenbrook is saying certain things. Robbie. I'll try to keep it professional.
Well, it is professional to call me Robbie. I actually consider it unprofessional to call me Mr. Essenbrook.
Okay. Well, very clear.
You call me Robbie.
Sure. Yeah, you can call me out.
Okay.
Yes. All right. Well, that's fine. I'm simply attempting to understand why there's this continual impasse at arraignment over the issue of jurisdiction. Okay. And so it appears to me, after a couple of incidents I've seen in a couple of courts, that it derives from a mistaken belief as the duty of the court to make certain statements regarding certain issues, specifically jurisdictional issues.
But I don't care about the court game. All I care about is if somebody's going to point a gun at my head and they go somewhere, I want to make sure that they are actually allowed to do that before they point the gun at my head and they go somewhere. That's all.
I mean, by the same logic, this Mr. Taylor is going to argue that there's no need to even bring up a cause of action. There's no actual need to ever have a actual victim. He's going to say that these are all completely unnecessary and that this religion enforced via statutes and codes is perfectly logical and reasonable, and anything about a challenge to jurisdiction just doesn't make any sense. The purpose of this meeting, from what I'm gathering, is to try and convince Robbie that this challenge to jurisdiction has no merit when the evidence of the last, 10 months in a row would, argue otherwise. That's called evidence.
Okay. All right. So please explain to me what you mean by evidence in this regard.
The recordings, the court's own recordings of their judges and their prosecutors. And let me give you a perfect example. The prosecution that's been screaming the whole time, we have no answer. I'm just relying on the judge to save them, okay? But saying, we're not answering that yet. Judge Leslie Roberts, was it? Said on the record that the prosecution had submitted evidence of jurisdiction. And when Robbie brought up the difference between what the prosecution was saying and what the judge was saying, she immediately resorted to violence. It was quite comical. This issue is relevant. We are aware its relevance. We are aware of the big picture implication of its relevance. And no amount of a lawyer trying to convince us that jurisdiction isn't a matter when so many judges, despite all of their power, again, bailiffs, guns, and tasers and orders, have been unable, powerless even, to move Robbie one step past step one without the evidence of jurisdiction being addressed. So please stop insulting our intelligence by pretending this is a non-issue. We do not buy it. We do not believe in this religion. You have a monopoly on power by statutes and codes and a constitution 240 years ago. We're not claiming to be sovereign. We're not claiming to be constitutionalists. We're not claiming anything. We're just asking to clarify what the accusers are alleging. And we're trying to do so without being coerced or under duress. Because so far the courts have said if you don't sign a document that says there is no coercion and that you are doing all this voluntarily, we will not accept a plea. We will take you to a trial by judge. You know he will punish you and you will do time in jail and fines when the plea on the table has been 8 hours of community service. We know exactly what's going on here, sir.
I see it all as due process violations, and I see it as the judges and prosecutors have been committing crimes. I have evidence of judges and prosecutors committing the crimes of false imprisonment, extortion, conspiracy to commit fraud, terrorism, and criminal trespass.
And that's just over one TSA arrest.
Anybody who assist them in their criminal activities will end up going to jail. Because as far as I'm concerned, now this is a criminal investigation. So I'm just letting you know that these are the stakes.
Very good. Well, I'll tell you what, since it would appear to be entirely unproductive for me to attempt to either advise you as to what the law is or to attempt to comprehend the source authority under which you're operating on your beliefs, because generally speaking, that's how the law operates. It has some authority, some source.
The Socratic method of investigation. We don't need any authority beyond that. Please stop asking for one. It's irrelevant.
Since you insist upon taking that position, there's very little that I can do other than assist you in a formal sense. You have motions that you need to have typed up or put into some form for submission. Since we have an electronic filing system now, if you need assistance with scanning those documents and filing them with the court, I'm happy to do that for you. I'm happy to proofread for grammar and spelling if you like. Of course, with your permission, your ultimate approval, any documents that you wish to submit. Beyond that, since this seems to be sort of intellectually closed. No, if you'll allow me to finish.
I will.
Some sort of an intellectually closed system, and that I'm neither capable of offering you information, advice, or opinions, nor am I even really being permitted to have questions answered so that I can understand the perspective that you're developing and what its source authority is.
There's no burden on us, sir.
My function is fairly limited. And so, again, I'm happy to provide any of the services I just mentioned in order to assist you in proceeding in the way that you see fit. I can assure you that your friend here is misleading you, and that you have chosen a difficult.
Explain to me why you believe that he's misleading you.
Because clearly his beliefs and assumptions about the process are incorrect.
Can we dispense with the idea of beliefs and assumptions?
There are beliefs and assumptions.
Can we only deal in facts, please?
We don't believe anything else. Period. If you say an opinion, we don't believe it. Period.
There's nothing that I will believe unless it is supported with factual evidence. Okay, I have factual evidence of judges committing crimes of extortion. Okay, now since you are a member of the court and you have an obligation to the court, I assume it is also your obligation to ensure that judges and prosecutors are not committing crimes. Would that be a correct assumption? Are you obligated to ensure that judges and prosecutors are not committing crimes?
Well, not exactly.
So if you witness and come across evidence that a judge has committed a crime, you're not required to report it.
Well, as a member of the bar, if I suppose that if I saw a judge hitting another person or stealing your wallet or something, I see it. But the problem is what you call facts, to some degree, your belief as to what facts are, and to some degree, they are your opinions as to what those facts mean, and what you call them. Okay? So, say, for instance, that a judge requiring that if a person enter a plea of guilty or even a plea of no contest, that they do so voluntarily, and if they say that they're doing it voluntarily on the record, to say that that is extortion, which is, I think, part of what you're saying.
Never what I said. Well, I heard one method of extortion was sign this document within 15 minutes or else you'll go to jail.
Well, see, so okay. Well, I can believe that that actually occurred, but to say that those facts constitute the crime of extortion and coercion or anything, no, I would not agree with that opinion.
So you're saying that if I put a gun to your head and said, I will shoot you if you don't sign this form, and now that you've signed it, I'm going to hold you legally responsible for everything that it says. You're saying that is not a crime?
Of course it would be, because you don't have the legal authority to do that. There are some things which
He's not pointing at the gun. Oh,
gosh. Vested in its words to administer and the law. So some people can do things that other people can't do. So, for instance, if I go into court and start arguing on behalf of a person, I'm perfectly in the right to do so. If Joe walks into court and begins to do that, then he, of course, has committed the crime of practicing law without a license.
But I'm not attempting to even go to court. I'm being held against my will and falsely imprisoned.
You're required to go to court. Yeah.
Why?
Because the law says you're. Because we're all subject to the dictates of the criminal law.
Speak for yourself, sir.
Because otherwise, as I told you in the law library, the ability of a community to enforce its criminal edicts precedes even the existence of government itself.
Sir,
it's a fundamental element of all communities that there are rules, and the community has a way of enforcing the rules.
Is it a fundamental? Is it a fundamental of a community to get a bunch of money and men with guns together and monopolize the rule based on a geographical, physical location alone, no authority, which you so obviously want so badly from us, no authority, no evidence of the ability to do so. We're just going to get a bunch of money together, men with guns, and rule this place. And anyone else who wants to have anything outside of that, too bad. We have guns and tasers. So please don't speak to me about, edicts of law and all these. It's earlier, sir, Mr. Taylor, you rightly came to the conclusion that you weren't going to be able to convince us of this nonsense. You're not going to be able to convince us that the quote-unquote law, which is nothing more than the opinion of the senior ranking bar member in the room, sir, practically speaking, is somehow, it's necessary and it's all a community and you guys are against the community. We're against no such thing. We're against forcing people under coercion, coercion. We are for voluntary interactions where people get to do what they want among a series of choices, not a monopoly where 15, 30, 40% of the population rules on a leader because they can't handle ruling them, themselves. And now that ruler gets to have men with guns do everything. Everything. Drug war, education, everything. I'm not going to rant and go into it. I'm pointing at the big picture that I know is going on. Please don't insult our intelligence by trying to convince us of the nonsense religion that supports your career field, your paychecks. Thank you.
I do want to, before we go further, I do want to clarify something. Are you allowed to discuss anything with the judge or prosecutor about what we talk about?
Of course not. Attorney-client privilege applies to all of our disputes.
You're not his attorney. Why are you claiming attorney-client privilege when you're not his attorney?
Excuse me, do you want me to go talking about the stuff that we discuss in confidence? Let's try to exercise.
That's not the point, sir. That's not the point, sir. Why did you mention attorney-client privilege when you're not his attorney? I must have struck a nerve.
He asked me if our discussions were confidential. I said, yes, they are.
Then why did you cite attorney-client privilege? Because that privilege only extends to people who are represented by some... Are you going to let me finish or not, sir? I think you're not letting me finish because you know that the question is damaging to what you're trying to sell.
Nonsense. What I'm trying to be clear on is that even though I am not attorney of record, while I'm acting as legal advisor, attorney-client privilege applies. That's all.
The legal advisor capacity is one forced by the court. It's not one recognized by us.
It doesn't matter what forces it. The question was, are our discussions confidential? And the answer is yes. Now, I can't imagine why it would be in Mr. Estabrook's advantage to Mr. Estabrook's interest for our conversations not to be confidential.
No one is proposing such a ridiculous thing, sir. No one's proposing anything so ridiculous.
Why you are objecting to or quibbling with my statement that our discussions are confidential is something that, again, puzzles me in respect to this intelligence which you keep talking about and insisting that I not insult.
Well, I think it's pretty important to clarify under what purpose or reason that you believe that you will not
I'll tell you why. Because attorneys want
me before I finish, because I'm attempting to make a point. Okay. I want to know why it is that you believe that you would not communicate with the judge or prosecutor, because I want to make sure that you won't use some sort of, loophole, whatever legal religion loophole that you may have. Now, I do have a situation where Jane Fox violated what you call the attorney-client privilege, and it caused me to end up going to jail. And so I'm just wondering, can that sort of...
Can you tell me a little bit more about that so I don't make the same mistake?
That's a distraction. Continue.
No, it's not a distraction. Please, you're the distraction, but never mind.
I'll take that as a compliment.
So,
I imagine you would.
Jane Fox spoke in the court while the record was not running to Randy Weisberg and whoever I have never been able to get that prosecutor's name, and told her about the conversations that we had on the phone. She stated specific things that we had talked about and proceeded to laugh with them and joke and then say, I'll be sure to tell, Mr. Esterbrook what we talked about. Well, not everything, but, So then she came to me and completely mischaracterized what had been discussed, but she violated attorney-client privilege.
Well, I'm sorry to hear that, and I hope that you address that issue to the state bar.
Well, I'm wondering, since you're a legal advisor, injury caused because of this happening. So I want to know, can that be fixed, or is that something that I'm going to have to go forward with?
And my short answer will be, I do not represent you on claims against prior attorneys, or nor do I technically represent you on anything. But but my scope of my role as your legal advisor is Multnomah County Circuit Court Case 16 TR 11512.
And that is what this is in reference to.
Well, but it is only in reference to the criminal charges contained within that charging instrument, not into any collateral matters involving either inadequate or ineffective or inappropriate assistance of counsel. It is not in respect to claims of ethical violations by prior attorneys or anything collateral to the criminal charges itself.
If they're using that record still in each hearing that I go to, they're using that injury and reaffirming the injury every time I have gone to court.
Okay, well, I can certainly, to the extent that you want me to do so, or I can assist you in insisting that anything that was information derived or prejudice resulting from an ethical violation be disregarded, stricken from the record, etc.
For example, the not guilty plea that was entered on the prosecutor's behalf.
When an individual refuses to enter a plea,
I didn't refuse to enter a plea, so that is not something that you can use as an authority.
The court will enter a plea of not guilty unless an individual enters some other plea in accordance with the procedures required by law.
And I believe that's what I was doing. I was attempting to enter a plea.
I didn't think we could help.
Well, then you're talking about your religion, so I'm simply being forced into this game, and I do not wish to play it. So
you were entering.
Again, you're talking about law. No, I didn't say I believe I was entering a plea.
You started to say you believe something.
Maybe you should let me finish then, from now on, instead of interrupting. Joe, go ahead.
Well, the whole issue of entering a plea, I mean, yeah, he recited the PC approved sentence for the plea in the courts, but in there is that they intentionally leave matters vague so that they're hard to understand. Ask if you understand, bind you to it, and then do everything possible to push you through both the plea and either to accept a bar member for assistance, which is just someone from your opposition, or to waive a right with no benefit whatsoever. If you don't do these things, they will then force it on you. If you object and say it's not with your will and that the judge isn't your lawyer, they'll do it anyway, claiming that you're refusing. But you're not refusing. You can't understand something that is intentionally left vague. We seek to clarify what it is they're alleging, and they refuse to do so, and then back it up with the gun of the bailiff while they run off the bench after putting our name last so that there's no one else in the courtroom to hear it. We're pointing at that, sir. Not something that you can twist and kind of argue to make your side look better. For instance, when Robbie was saying the extortion example, he was saying if I put a gun to your head and tried to force you to say, you either sign this paper or go to a cage, you knew exactly what he was talking about. But you said, oh no, that would be a crime because you can't point a gun to my head. You knew exactly what he was talking about, and you're just attempting to distract. I don't even think you have a good faith effort here just demonstrated for us to continue, talking about this in the court. I think we should be best if we moved on to what it is that Robbie wants to get your help, if we can call it that, with anything in the first place. As I understand it, there are two issues that Robbie may want your help in. Maybe we should move to that, because we're not making any headway trying to convince each other that we're not going to believe in your Constitution, statutes, and codes.
So, since I'm being forced into this game, I want you to find out from the prosecutor, has he submitted evidence establishing jurisdiction for this court to impose upon me? I would like a written and signed affidavit of facts. And hold on, I'm trying to write it all down. Okay. And that's factual evidence. Well, you say that as though that's a given. Yes, they
well, I mean, there is such thing. Okay, so you want an affidavit? What's doing what now?
I want a statement saying yes or no, we have submitted evidence establishing jurisdiction, or we have not submitted factual evidence establishing jurisdiction. I also want the court to clarify what it means by the maximum penalties, by the fine. I would like to know what it is asking for specifically when it indicates that I may possibly be fined.
Okay, hold on. I'm a little confused by that question. So what do you mean clarify what it means by the maximum?
Well, so Tom, go ahead and what
maximum penalties are set forth in the statutes.
Right, and I'm attempting to clarify what it means when it says such and such fine. I'm attempting to clarify what that possible punishment is.
Well, I can do that.
We would like the court to do it because your opinion doesn't issue orders or control cops with their guns, please.
Well, excuse me. I mean, a statement of the maximum penalty that's set forth in the statute. Anyone can look that up for themselves.
We're not asking for that. Robbie made that clear just a moment ago.
No, he didn't make it clear to me. He asked what was meant to clarify what's meant by the maximum penalty. Well, they mean what they say.
I'm asking what does it mean such and such fine? What is the court asking when it indicates that is a possible penalty?
Well, it's not asking anything. It's informing you of what's the maximum financial penalty that could be imposed.
And I'm asking, what does that mean? What are they specifically requiring if they choose?
What do you mean? What does it mean? What do you mean? What do you mean? What does it mean?
You're telling me that I can be punished in some way,
right?
And I want to know what you mean by that punishment. I want a full definition of everything that is being asked for. If I
want a definition of what $6,250 means,
I would like to know. I would like to know, for example, what do you mean by a $50 to $50 fine? I want that clarified.
What do you mean? What do you mean? What do you mean? What it means? It means a fine imposed by the court, a potential obligation that you would be ordered to pay in an amount not exceeding $6,250. I mean, does the number $6,250 confuse you?
Explain to me what by dollars and what it is.
What do you mean by dollars?
Specifically, that it's being required.
Are you freaking kidding me? What do I mean by? I can show you what a dollar is.
Okay.
Well, then don't insult yourself by pretending you don't know what a dollar is. Did you buy that water? Were you confused when they asked you for the money for that bottle of water?
Or a relevant clarification. And I want this to be, I need to be informed.
It means the same thing it meant when you went to buy your coffee and they asked you for money.
That is completely irrelevant.
No, exactly.
Nobody is forcing me to do something if I voluntarily make notes.
Yes, it is.
First off, quit interrupting. Nobody is forcing me you're again using a logical fallacy. You're creating a straw man by attempting to say, well, you did this and blah, 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 and you're making assumptions about how I obtained something. So I want to know specifically from the court, if it says you will be issued a whatever amount fine, I want to know specifically what that court is requiring of me, and if they are requiring me to engage and contract with a third party in doing so.
Okay, well, I can answer that. The court doesn't want, because they don't need to. There's no authority to require them to. What the court is doing is the court is providing you a portion of your due process right, which is that portion involving notice. And it is giving you notice of what the statutory maximum penalties for a particular crime are. Those statutory maximums contain two portions. One is the maximum amount of incarceration or confinement. The other is the maximum amount of financial obligation. Those maximum amounts mean what any person of ordinary intelligence understands them to mean. So a year as a maximum penalty for a Class A misdemeanor means a year. It means a year as you have known a year to be since you have been a small child. $6,250 maximum penalty means $6,250. You know what a dollar is.
Are you presuming that I know something? I am presuming. I need to clarify. I am presuming I don't.
Yes, I am presuming that when you walk into a store or coffee shop or whatever and are asked to pay a particular amount of money it's not a straw man, sir. What I'm saying is, you know, for instance, if the clerk gave you adequate and accurate change, you know what you paid for.
I don't even know how this is right.
I'll tell you because you understand the concept.
Stop interrupting me before I finish a sentence. Can we please act professionally?
That's certainly a question, isn't it?
Well, I've been acting professionally.
Well,
I've been asking for clarification, and whether or not you think that they are nonsense or not, I don't give a damn. Okay? I am asking for clarification from a person who represents the court. Okay? So it is your job to supposedly inform me of the cause and nature of the proceedings. Then I need to know specifically what the court is asking. And if I ask a question of you, then please answer the question that I asked and not a question that you're pretending that I asked. I am asking you to explain to me what the court is asking for or requiring of me if it institutes a fine.
Okay, so let me make sure I understand you correctly. Because when the court informs you of the fine, they are not asking for anything. So your premise, which is that they're asking you for something at that point, is a false premise. It's a false premise.
I don't understand the punishment. Okay. So I want to know what is the punishment.
Okay, once again, what the court is informing of you when they state the maximum penalties, they are meeting their legal requirement to inform you of the maximum penalties. It is presumed, and I think reasonably presumed, irrespective of what you may say here, I am confident that you know what a year is and that you know what $6,250 are. Well, the court is not informing you of what will happen.
Okay, so I can give whatever I want.
May I?
Please allow me to finish. The court is not at that point imposing any particular fine. So they're not asking you to do any particular thing at that point. If and when you reach the point of being sentenced, then the court will inform you. If there is a fine imposed, they will inform you of the amount of the fine. They will inform you of the method of payment that is expected of you. So all of that will be a portion of your judgment if you are convicted of the crime. So you will certainly, at the appropriate time, be informed of everything you seem to be, as nearly as I can tell, asking.
So you're telling me that I don't get to understand what these possible penalties mean until I've been sentenced?
No, I didn't say that.
Well, you're telling me that I'll be informed at sentencing of what that means.
No, I said that what your initial question was, what is the court asking of you or asking you to do?
What is the court pointing a gun at my head and saying this is what we may require you to do?
They're telling you it is precisely what they say it is. So a year is $6,250.
Okay, explain. $6,260.
What don't you understand about $6,250?
Let me
So they wouldn't be asking anything about them. Go ahead, Joe.
Okay, I'm just going to try and shift gears for the sake of, productive communication here. Let me put it another way. Saying that we understand what a year is pointing at 365 days, a universally understood, irrefutable measure of time, easily comprehended by anyone. A unit of currency, $6,250, has no such credible foundational rock to stand on. You're misrepresenting, you're borrowing credibility from something that does. Money is just green pieces of paper printed by a third-party bank. And I don't want to hear arguments of, oh, well, it's common. Oh, well, any reasonable, rational person. Oh, well, it's this way. We do not care that the system is so corrupt that 99.9999% of everyone just goes with the flow. That has no bearing whatsoever on the relevant matters here on the table. The court is expecting, or will, Robbie to somehow attain this money from this third-party bank that prints it, and then go to the courthouse and give it to them so that they don't further impose upon them. We would like a motion addressing the court's use of quote-unquote dollars with no further clarification whatsoever allowed to happen, or even be entertained as a legitimate question when everyone knows it's well within the comprehensional limitations of everybody in the room. It's not hard to understand. Please don't try and, oh, that's nonsense, oh, this, that, and the other. We want the court to simply be clear. We're asking the court to be clear. We're not even asking the court to, oh, go ahead and file a dismissal on the charges at this point. Just be clear on what you're threatening Robbie with. I think that speaks to the cause and nature of the charges and allegations, and hence punishments against him.
Well, you're free to think that.
Well, I need to be informed of the possible punishment so I know whether or not I should take the deal or not. And that's all I've been trying to do, is determine whether or not I should take the deal. And I have the question regarding jurisdiction, and I have clarifications regarding what the court will or may require of me if they find me guilty. Because I still have no idea what it is that they're talking about when they say this may happen if you are found guilty. I have no idea. And
oh, I'm sorry. I would not. I cannot imagine a clearer way of explaining it.
And that's going to be the fallback.
Explaining the maximum penalties other than by stating them in plain English. Okay, so if the court institutes a $1,000 fine, what are they asking me to do?
$1,000.
How?
They won't.
What are these dollars?
What are these dollars?
Yeah,
the same dollars that you used to buy that water.
How are they? What do you mean? How do you know how I acquired the water?
Well, I hope you didn't steal it.
There are other forms of currency.
I assume you bought it. Generally speaking, it's a United States currency, legal tender.
Oh, now we can. Yeah. Now we're talking legal tender. So the court wants to force legal tender.
The same thing that stores require. I don't know. Are you housed? Do you live somewhere?
Sir, stores don't point guns at us. Stores don't issue orders and point guns at us and put us in cages. Please stop using the logical fallacy of trying to borrow credibility from less threatening sources.
I assure you that the store would in fact take you into custody if you attempted to walk out with that water without paying.
You know exactly. Are you saying that there's the same amount of power in a store as in a courtroom, sir? How is it that people get away with shoplifting then? Please.
I would say that the stores have some portion of the power which the state has.
Oh gosh.
I have certainly had numerous clients lawfully taken into custody by store. What do they call those guys? The store dicks. I forget the official name they use for them. Under circumstances which, if I had attempted to do it, would have constituted kidnapping. But which, in fact, they have derived certain portions of the state's coercive power in order to protect their property. So, yeah.
You're comparing those two with a straight face and expecting us to believe that.
I absolutely am. And I'm saying that meanwhile, I have someone sitting in my office pretending he doesn't know what money is with a straight face.
We know exactly what money is. We know exactly what money is. Who doesn't know what money is?
Exactly, and so if I say that when the court, I'm almost done. When I say that the court, at the point that they are informing an individual of the maximum penalties, is not at that point requiring the individual to do anything other than understand what the maximum penalties are, if you can. But that at the end of the case, if in fact a conviction is entered, and if in fact a fine of some sort not exceeding the amount that the individual has been notified that would be the maximum amount is imposed, that at that point the individual will most certainly be advised as to the expected schedule of payments and manner of payment, but not prior to that.
To clarify, are you saying that the United States currency is money? Is that a yes?
Yes, it is. So it is every time I use it.
Okay, so you're saying that United States currency, and which United States currency would you consider money right now?
Anything issued by the United States, I'm still at that.
So anything issued by them?
Any coins or paper money that is issued by the United States is
Okay. Then quickly, can you define the United States so we know who to go to get this?
Oh, you don't have to go. I mean, it's in general circulation.
What is that? Again, I'm sorry, I don't know why. So the court is going to require me to make a dealing with the bank?
No. You can get your money any lawful way you want. You can borrow it from your mom.
But, okay, so the court is going to require me to contract with a third party?
No, it's going to require you to produce the funds necessary. If it imposes, if and only if it imposes a financial obligation.
Again, I don't want to deal with what may or may not happen. Hold on. Before I am forced to play this game, and while I am making decisions on whether or not to take a plea, I would really like to know about the maximum penalty before I am sentenced. Okay. And that is why I'm attempting to be informed of the cause and nature of these proceedings. That is all. So I want to know specifically, because again, you told me that I need to contract with, the court may require me to enter into a contract with a third party.
I didn't say that. Okay, well, you have to lawfully come up with the money that you're supposed to give it to.
What saying the same thing.
But again, I'm trying to be as clear as I can be. The court, one, may or may not impose a financial obligation.
So
the only thing I already know it may or may not.
And I'm attempting to clarify the possibility of this possible sentence or punishment. So can I go ahead and get an affidavit from the court, from a judge preferably, that explains and informs me of what it means by a $6,250 fine and what types of dollars it is specifically asking for and what it is required?
Well, no, the answer is the court fine.
So I can't be informed.
Well, no, the questions you're asking are ludicrous. How are they ludicrous? Because $6,250 has its ordinary meaning.
Just because you believe that you understand what $6,250 means doesn't mean that everybody in this world is going to understand what is meant by that.
We're not requiring your opinion. We just require you to do it. You're either going to do it or not. Robbie is asking for something. We don't need you to try and convince us of something.
I'm not required to do anything except to provide advice. I'm not required to say a thing in court.
Okay. You said that you would. You said that you would help him. If you're going to help him, then do what he asks you to do. Don't try and convince him not to do it.
No. Listen, I'll be clear on this.
That would be a first.
My job as an advisor is to give advice. I'm going to give advice based upon my understanding of the law, not your delusion.
Okay, but let's
be clear on that.
That's your role.
If you would allow me to finish.
Oh, okay.
I said that if Robbie has particular motions or other legal filings of any sort that he wishes to file, I will assist him in drafting those entirely according to the contents that he wishes. I will type them up on my computer and offer them for his precise approval. I will offer editing in respect to, again, spelling, grammar, punctuation. I will offer my fairly well developed skills at legal writing if he should choose to employ them, though I will not obviously disclose those. I will.
Sir, we believe this part. Okay.
I will then file those with the court according to the electronic filing system that we now use.
Yep.
I will do all of those things. I will not myself, over my signature or with my voice, make ludicrous arguments anywhere.
Okay,
I simply
great.
will not do that.
Okay, so
I will assist Robbie in making any argument he wishes, irrespective of whether I think it makes a lick of sense. I will, on the other hand, in confidence and in the privacy of my office, to the extent that we have privacy with you here, I will offer my opinions, because that is the essence and most fundamental element of my role as a legal advisor, is to provide legal advice.
Okay, I listened to all that.
I will not be deterred in the provision of legal advice by the fact that you seem to, and again, you appear to be the direct source for his delusional beliefs. I will not pretend that those beliefs are not delusional. I will not suffer ludicrous and absurd arguments such as, I don't know what $6,250 means, from a person who clearly of above average intelligence, because it's facially ludicrous.
Okay, now I would like to be able to speak with an equal microphone.
If I were to say to you,
No, dude, you need to give me a break now. Okay, you've spoken for a whole minute. I need to get a break in here. Then you can speak more.
Which one do you want?
Sir.
You would not. Let me finish my thought.
No, because it's taking 2 minutes long, and you need to give a break for the other side to respond. You can't just ramble on and on and on, and I'm just going to let you go on for 5 minutes.
I am not done.
Well, please wrap it up, because all the only thing you've done so far is repeat yourself. This isn't even relevant. How much longer am I supposed to listen to irrelevant issues you're repeating?
I have to tell you shut up.
Hurry up.
I would have said, don't tell me hurry up.
I'll tell you to hurry up all I want.
I'm sure you will.
So don't tell me what I can and can't say.
Okay, well then don't tell me what I can and can't say.
Well, hurry up. You're being boring and you're repeating yourself, sir.
2 stacks of money, one of them $6, the other $6,250. You would have no trouble knowing which one to pick up if I gave you a choice. You haven't clarified what you mean by it. You would. No, I'm going to make an assumption. Yeah. Okay. Are we talking advance hours? Are we talking about fighting currency? Are we talking Federal Reserve? Federal Reserve? Are we talking gold? You know what I'm talking about.
He's not going to let you finish.
I'm telling you that if I did that, if I put $6 to one stack, $6,000 $6,200, that's $6 of what? $6 of what? I'm going to finish my thought. Explain what a dollar is. You stop interrupting. Fine dollar.
This is pointless.
No, you can stop interrupting. No, you're interrupting.
You have yet to let anyone finish. You won't let me finish. You won't let him finish. But we're expected to let you finish. This isn't good. This isn't the presidential debate, sir. That's not how this works.
The simple fact is, if I put a pile of $6 and $6,250 in the other pile, you wouldn't be sitting there telling me to decide what I meant by the money. You would simply take the $6,000.
We would be if you were pointing a gun at us or threatening us with a cage. Do you understand? We understand that you're just repeating your religion, but here's the big picture, and we know you know this picture. Now, I'd like to be able to speak without being interrupted, if that's okay with you.
You would take the money. I would be able to speak. You would take the larger pile of money. No, but if I put them in an envelope, you're making an assumption. I'm assuming that you're not. First off, and it may be interrupted. I'm assuming you're not a fool.
He won't stop interrupting.
If you were to set a pile of something here and a pile of something here, then I could choose. And you said, choose whatever you want. I can choose what you want. But for the purposes of this hypothetical situation, you are not clarifying what you mean by dollar. So, because once again, because it speaks for itself. It doesn't speak for itself. No. Okay, first, you wouldn't be having this argument if you had the money. First off.
Says you.
The reference. No, you know what it is. The Criminal Code of Oregon is a religious document that shows. How is that silly? Because it's not a religion. How is it not a religion?
In practice, it is.
It's factual evidence that applies to me. Yeah. Okay, what is the factual evidence that applies to me? Because
before you answer, when you answer, what is the factual evidence that applies to me? I want you to explain why 10 judges and 5 prosecutors have not been able to explain to me factually how that applies to me. So here's your opportunity.
Well, the answer is it's not that they have not been able to explain it. It's that you have not been willing to address yourself to comprehend or listen to the explanation.
Burden of proof.
In the same way that I can't seem to explain to you that money means money. It has nothing to do with the source of the explanation. It has to do with your absolute distance to pretend you don't understand. I have dealings all over the world with various different kinds of people in various different kinds of places. And they don't even all use the term money as you're talking about. So I am being threatened by an organization which says this is what we may possibly require you to do if you decide to go down this road, this avenue of our game. I'm attempting to clarify what that thing is that they may require of me before I'm being sentenced and surrounded by armed people. So again, quit calling this ludicrous, because I can point to millions of people who have no idea what kind of dollar you may be talking about.
You're not one of those people.
You don't know that.
Can I clarify?
Again, I have you're telling me what I know. What's obvious? How is it? I contract with so many different people. I have to clarify what it is that they are asking me for. So this is the only organization so far which has refused to clarify what it is requiring of me. So go ahead and tell me what factual evidence you have that the Criminal Code of Oregon 2016 applies to me.
The fact that you're sitting here in my office within the state of Oregon.
Okay, well, geographical physical location is nothing but an opinion. Where his body happens to be at the current moment in time has nothing to do with it. Nothing about the precious Constitution. Excuse me! Excuse me! Excuse me, sir! I'm talking, I let you talk. Now please let me have at least 2 minutes like I let you have. The Constitution that you give... Excuse me, sir. The Constitution... Excuse me, sir. Excuse me, sir. Might I be striking on a nerve if you don't even want to let me speak the words out into the air? The Constitution that you... The Constitution that you swear an oath to that we know means nothing, but that you swear an oath to speaks nothing of its applicability based on geographical physical location. That is your opinion, sir. We will not be jailed and fined because of your opinion. It requires evidence. So please stop trying to distract us with the typical least common denominator tactics, really, too. We've been dealing with that one for over a year. That's so yesterday. Please, Harvard ought to prepare you with better than that. As far as the money issue goes, please stop trying to pretend like we're dumb and we don't know what money is, okay? You know that we are pointing directly at the fact that the entire justice system is built around this third bank that prints money, and then the whole system operates on it. And if you don't just knowingly agree that that's money and that you know what you're doing when you pay it and what it all means, then screw you. We're going to pretend like you're the crazy one. I don't care. Okay, that tactic doesn't work. And for lastly, calling me delusional. The definition of delusional, sir, is believing in things absent evidence. Okay? We are doing nothing but asking for evidence and relying on the past evidence. I'm not going to go into it with you, past evidence, because you obviously are a member of their religion and you're going to defend the faith forever. I'm not interested in non-productive conversations with you where you're not exercising good faith at all, but just repeating the judge's will. That's what we're pointing at when we talk to money. So if you're writing something for the court and asking them to clarify what they mean by this fine, we are pointing at the fact that they are forcing us under penalty of a cage to go to this bank to use this certain form of one currency in the world to acquire enough of it somehow and to give it to the court in order to satisfy the men with guns. We are pointing at that. We know you know we're pointing at that. And any attempt by you to brush this off as, oh, you know what money is beneath us, sir. Frankly.
So let's stop going around the merry-go-round when we're not on that merry-go-round. We're on the big picture. We know what's going on here. We're one of the few that are effectively challenging it, and get used to more of us coming, because it's a new age with the internet of transparency and accountability against the lawyer class. Now I'm done. Go ahead. Speechless. It's probably the most productive use of our time we've had today. What do you say, Robbie? Should we wrap this up, or show them what else we want, or email it to them, or where are we going?
Well, so I need to set a meeting for us to, for me and Lawrence to listen to the recordings of the hearing, and so I can let them know what motions need to be filed.
Perfect.
And so it's going to have to be a rather large chunk of time, and I need Lawrence LT to order the recordings of all of the hearings.
Oh, you don't have those yet?
I have some of them.
All right. Well, okay. Well, let's get a list. Well, I can get that off the computer. Why don't you tell me which ones you pulled? Here, I'll tell you what we'll get the record of your case here. Figure out what all the appearances were. And then you can tell me which ones you've got, but I don't duplicate by ordering. And we'll get those ordered.
Well, one that would be and they just want you to order all of them. Well, they have made mistakes where they take out some of the evidence of their criminal activity by not allowing me to have the full
Right, yeah. Let me just go ahead and print this out. We don't have to do that if you hear it. Okay, so we'll go ahead and make those orders today. It won't be this week. Let me see what we can do. Monday's bad. I should have some time. Well, I've got a case going into trial probably a week from Monday. So if we're going to have a huge time, it'll probably be after that. And I've got another case the following. You're set out December, aren't you?
I believe December 1st. I think there's another.
You have a call date. You have a call date on the 1st of December. You have a trial.
Is
for this proceedings.
Another.
Yeah, that's just for the proceedings. They like to get an idea what the status of the case is. I do have a couple of pretty significant trials, but obviously we want to get this going quicker rather than later. So let us say, it's challenging to make this work. Why don't we look at the 9th? Well, I don't think I'll have them ready by then. Of October. Oh, today is the 11th.
Well, I call them. They usually have them.
Okay, well, let's do that. We'll have them ready then. So why don't we try and get together on October 19th, it's a Wednesday. See, my problem is I won't have time to listen to any of them before.
Well, we're going to listen to them together.
I was my hope to be prepared. I like to have done all the reading beforehand.
Well, the thing is I need to go through them and be able to say this is where we need to file a motion for prosecutorial misconduct. This is a witness we need to subpoena for this reason.
Sure. Okay, well, let's say Wednesday, October 19th.
Vacate a plea, things like this.
How early do you want to get started?
How early can we get started?
I would say 9.
9 a.m. here.
Okay, so
I also need you to subpoena every magistrate or judge because I intend, if I'm being forced into trial, I intend to call them as witnesses since they seem to have first-hand knowledge that there is factual evidence of jurisdiction. So I can name each of those people if you'd like.
We can prepare subpoenas for you to sign. I can't sign those as legal advisories. I can't do something that I know.
Yeah, as long as you're preparing the subpoena, I'll look it over, and if
I will prepare the subpoena
So I'm not representing myself. I'm defending myself against criminals. Can you explain to me what it means to represent? Like, how do I?
There has to be two of you. They can't have just one. They got to be two of you. Sorry, go ahead.
Yeah, is there some kind of duplicity that I'm not aware of where I am being seen not only as who I am, but I'm also somehow like I failed to see, like, from my understanding, a representation is a copy. So I want to know how it is that they're saying that I am representing myself.
I guess let's start with does a representation mean a copy? Because I'm not sure that's what it means.
To represent means to present.
Well, that might be the etymology of it. But okay, to represent. Let's see what the relevant part, relevant definition.
It accepts their jurisdiction.
This is Oxford English Dictionary. I call it a dictionary.
Is it opinions or the facts?
It's definitions.
And are they opinions of definitions or are they factual definitions?
Black's Law Dictionary?
No, this is an Oxford English Dictionary. The word represent has an ordinary term meaning.
It's good to clarify which we're talking about.
Did you say ordinary terms of meaning?
Go place up, deputy for, be entitled to speak for.
Okay, so
you're entitled to speak for yourself.
How am I replacing myself?
Yeah, no, it wouldn't be that portion of it. It'd be entitled to speak for.
How do you know?
Because we that's how we. Well, how do I know? Well, I would have known it even without an undergraduate degree in linguistics, but I happen to have one. I know it because no, I'm saying I would have known it anyway. I would have known it in the same way that everybody pretty much understands the language, unless they're engaged in this.
Robbie,
practice.
the legalese versus Black's Law Dictionary versus common law English isn't a can we want to open up.
Whatever. I'm not going to go around and around with these things.
Well, I'm asking, why do I have an entitlement to speak for myself? Isn't it obvious that I can speak for myself?
Well,
I just automatically do that anyway.
Well, sure. And as you're walking down the street, or
why this word represent?
Because I'll tell you why. Because, for example, Joe would not be permitted to represent you. Why? Because the law says he can't.
But if I want somebody to represent me, why can't they represent me? And what law, what factual evidence is there that law applies?
Well, I'll tell you why. The same reason that if you wanted to have your appendix removed, Joe could not do it.
I don't want, like, if I have my appendix removed, and it's something voluntarily that I decide to do, so I will choose who I want to do it, right?
Well,
can't say just because you may believe that a person has to have some sort of piece of paper that says that they can remove an appendix. If I happen to know somebody that I know can remove my appendix who doesn't have this piece of paper, and I know that they're better at removing appendices than any of these other people with the piece of paper, then obviously I'm going to go to that person. So the key to this is that it is a voluntary situation. I am being forced to play this game, so I need to understand the full ramifications of all of these words. I need to understand what they are saying, what they are asking. I need to know all of the rules of the game before I am forced to play it. I enjoy playing, fun games. I don't enjoy being forced at gunpoint to play a game. So if I'm being forced at gunpoint to play a game, I am going to require knowledge of all of the rules of the game before I am forced to play it. That will allow me to be informed. You still have yet to answer the question of what factual evidence do you have which shows that the Criminal Code of Oregon applies to me.
Or me.
Let's go back to the analogy about the unlicensed practice of medicine. You may very well have the physical ability to have somebody who doesn't have a doctor's license perform surgery on you. However, if that came to light, the individual could be prosecuted for doing so. Well, no, it is. It goes to the fact that there are laws regarding professional licensing.
And if they're not going to allow me to buy,
if you
Surgery isn't a courtroom. Deception is not medicine.
You may not enjoy what you're calling this game, but it is not a general feature of the criminal law that persons subject to its enforcement, that is, criminal defendants, are enjoying themselves.
Okay, what factual evidence do you have that I am a criminal defendant? What factual evidence do you have that actually apply?
The fact that you are, in fact, Robert Earl Estabrook, date of birth, July 2nd, 1980.
Oh, Jesus. Birth certificate,
know,
crazy. I'm the delusional one.
Even though, how many Robert Earl Estabrooks are there?
How many that are born on July 2nd, 1982?
Good question. Do you know the answer?
I don't, but odds are only one.
And somehow a birth date and a name gives you relevancy, gives you weight here.
Your identity certainly is something that you could plead, in respect to a defense.
Oh, you'd love for us to go down the name game identity. You'd love that. But we're not going to do that. Please stop trying that. We know what that is. We're not doing it, okay? You can't say, oh, your name and your birth date means you're subject to the codes. Screw the government. Our birth date is none of their business. Our name is none of their business. They force it on us. They force us to have one and use it. Otherwise, we can't even go about a daily life in this quote-unquote country. They force it one way or another. Please stop insinuating with fallacy after fallacy that medicine and cutting someone open and fixing their organs and sewing them back up is on the same level as practicing a career of deception and manipulation for the profit of the elite who rule this place. One is not the same as the other at all, sir. We see through all of this. Please stop trying these. They're immediately apparent. You are transparent in your arguments. Please stop that. Thank you.
So long as you go ahead, explain to me the factual evidence that Criminal Code of Oregon applies.
What's the factual evidence? Okay. Well, first of all, the application of law is a matter of law. Okay, let's start with that. Yeah, the application of law is a matter of law. Factual evidence may support. You just no, I'm not playing games.
We're not playing games. We're not playing games.
Let me. I'll define something else.
Why? Why not define law? Why are you jumping again?
Okay.
Because it's nothing. You stand on nothing, and you know it. It's the opinion of the senior ranking bar member in the room. It's a flexible thing that they can use to rule over people. That word law has no weight with us. The Constitution has no weight with us, and you have no evidence that it applies to us, and the whole system knows it. And that's why they don't ask people for their consent of the governed. And in the military, they most certainly do. They have evidence of jurisdiction because as part of volunteering, you sign jurisdiction. If it wasn't important, if it wasn't a matter, they wouldn't even bother with it. But they do. And it's because it is important and it is an element, and even your own judges will admit to that. And you're presumed innocent of it, they will admit to that as well. But when it comes to being presumed innocent of jurisdiction, oh, that's where the problems come up. So has the prosecution submitted it, yes or no? You still have yet to defend that, just so you know.
And I said they're not required to, and you don't like that answer, and so there we're in.
Okay, if what you're saying is true, then why haven't the judges been able to move Robbie forward past arraignment in 10 months of all these hearings and 2 different courthouses and many lawyers?
Honest answer?
Yeah.
Because of his obstreperous, non-cooperative approach to the proceedings.
What was that word you used?
Obstreperous. Obstreperous. Obstreperous, just like it sounds. You're a very smart fellow. You figure it out. Obstreperous.
There is no reason why you have to say that. You could use a layman term if you wanted to. Please stop using that as some kind of tactic of intellectual superiority. We see through that one too, Mr. Transparent. Come on.
Noisy, vociferous, turbulent, unruly, noisily resisting control.
Thank you much.
I've been simply asking a question, and it is the judges that have been choosing to yell at me and be noisy and violate the Oregon Code of Judicial Conduct, which they are supposed to abide by. Have you not seen that, or are you going to further mischaracterize me when you say that you are helping me?
No, well, I would say that the judges have, to some degree, shown fairly remarkable patience.
By forcing me to sign contracts at threat of jail, and by forcing me to accept things in order to have a proper defense, and by not allowing me to be informed of the cause and nature of the proceedings, you're saying that that is a remarkable level of patience. So are we dealing with psychopaths?
While running off the bench, running from you every time.
Well, I'm asking, are we dealing with psychopath judges who believe in the religion and believe that their only authority is through the use of violence, and that anybody who asks the questions that I'm asking, you're going to take a call right now?
I have to take the only person here. Go ahead. Hi, Lord Sailor. Oh, I would have called you if I were available to call you. I'm with a client. Okay. Did you receive the material I sent you? Okay, good. Yeah, there's nothing else. If anything else had occurred, I would have called you immediately. All right. No, you don't ask me now. I'm with the client. Thank you. I'll call you, like I said. Bye.
The reason I asked you to define what law is because I asked for factual evidence that the Oregon or the Criminal Code of Oregon applies. And if you're going to be speaking of laws, then I assume that you're going to be speaking about the types of laws which are, what's the word, unchangeable.
No. They're all changeable. They're all subject to amendment.
Well, again, there are laws which exist in this world which are unchangeable.
Like gravity?
Well, possibly. I mean, that could be an example of one. So when I'm asking about factual evidence, if you're going to cite law, then I assume that you are going to cite laws in fact and not opinions that you call laws.
So you will.
Okay, so factual evidence, please.
You
don't have any?
No, I'm saying the question you're asking does not permit a reasonable answer. It's not a reasonable question.
What part of it don't you understand? What part is unreasonable? Which word is unreasonable?
I'm not going to engage further in this.
Of course not. Of course not.
Well, it is. You're playing games with definitions.
Yeah, well, I'm asking for factual evidence. Since I am being threatened with possible jail time and some other threat, which everyone refuses to clarify what it means, I need to know what factual evidence is there that this code applies. So is there any or is there not any?
Well, you're presuming that the state has to establish their ability.
I'm not presuming anything. I'm asking you a question. What factual evidence is there that the Criminal Code of Oregon applies to me?
Quickly, it might mean the code itself.
Wouldn't that be a circular argument?
Well,
the law applies because the law says it applies.
Well, yeah, that is the case. The law applies because it says it applies.
Okay, so if I write down on a piece of paper, blah, 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 okay, this applies now because the law applies now, you owe me $5,000. Thank you. Okay, why not?
Because you...
No,
well, you could say it's guns, but it's not just guns. I mean, ask the Bundys, it isn't just guns. In other words,
I don't know
those yokels that tried to occupy the Malheur Bird Refuge, that are now in federal prison.
Yokels? Did you say yokels? Yokels.
The Criminal Code of Oregon is a product of the government of the state of Oregon, which government was instituted subject to the act of the territorial legislature back in 1958 and it continues in force as a result of the general consent of the people of the state of Oregon.
Wait, general consent? I didn't know you were a stand-up comedian. I'm sorry, that's hilarious. General consent. I'm sorry.
It doesn't require specific consent of any one individual. It is a generalized thing. Now, the simple fact of the matter is, if you want to place yourself in rebellion against the authority of the government,
who's doing that? Nobody's doing that. Nobody's doing that.
If you want to deny, see, the government doesn't have to explain to you why it has the authority to impose laws. You might think it does, but it doesn't.
Logic and ethics dictate international opinion, the weight of public opinion. We'll just see about that going forward, if what the judges are pressured or not pressured to do. They do have to explain logic and ethics in a courtroom or suffer the consequences of public opinion and being embarrassed off the bench. If you doubt that, we got a bunch of recordings coming up. You can see it yourself, sir.
Well, I think that's a delightful idea. I think that exposing these positions that you're taking to the public might be, I doubt it, but it might be enlightening to you.
It's not about me.
I want to know, it sounds like what you're saying is there is no factual evidence that the Criminal Code of Oregon applies.
I can say that.
Okay, so is there factual evidence that the Criminal Code of Oregon applies, yes or no?
There is, but you don't want to hear it.
Okay, so you're saying, I will say that's a yes?
I'm saying that it is.
Please just give a yes or no. No,
because you're I can see where you're going.
Well, no, I'm asking you one question right now. Is there factual evidence that the Criminal Code of Oregon applies to me? Yes or no?
Okay, and let me try to answer the question. First question would be, well, then what would constitute?
No, it's not.
First question is, what would constitute their factual evidence?
The question is, what would constitute factual evidence? What would it take to prove that the criminal code is
it's not up to me. You're the one proving to me.
No. You're not asking the question, and so I need you to define what you mean by the question. What do you mean by apply?
By apply?
And what
Impose?
What sort of okay. Now, I mean, for example, factual evidence that this pen writes. I write with it, right? Factual evidence as to the atomic structure or composition of this is less obvious. It might require some considerable research.
Right.
The question, what you're saying, and what you're asking, of course, as I'm sure you're well known, is the question of jurisdiction. Because that answer jurisdiction.
Okay, I don't. First off, jurisdiction sounds like some foreign legalese word that is in your religion. Okay, I haven't generally
you use it a lot in court,
because that is the only way I can communicate this idea of, has the prosecutor submitted this factual evidence for you to hold a gun to my head and say, we are going to falsely imprison you and force you to come into this room right now, otherwise you will be going to jail. So I want to know, I just want a yes or no. Is there, oh, you're not going to say yes or no. Is there factual evidence that Criminal Code of Oregon applies to me?
He said yes, but we don't want to hear it.
No, the application of the criminal code to you is not in itself in dispute. You see?
Yes, it is. Well, I'm asking, is there factual evidence that code applies to me? And I am that. So obviously,
the factual evidence is your presence within the state of Oregon.
Okay, I don't know what you mean by that.
You don't know that you're present in the state of Oregon?
First off, the state of Oregon appears to be the plaintiff. Okay, so I don't know how I can be within a plaintiff.
No. You see, you're confusing two different things. The state of Oregon means different things. It could mean it could mean the physical territory of the state of Oregon, or it could mean the government of the state of Oregon, right? And they are two distinct things.
You can't interchange them as is convenient to your position. The state of Oregon is listed as the plaintiff, sir. The plaintiff is the state of Oregon. You can't be like, oh, well, it can be this over here and this over here, whatever suits our wants. It's listed as the plaintiff. You can't be within something and that gives your rule book the authority to rule. That makes no sense whatsoever. And even you have to admit that.
No, actually, no, I don't have to admit that, because I can understand the distinction between the state of Oregon as the governing body of the state and the state of Oregon as the physical territory.
Either way, it's an imaginary opinion.
So what about the distinction between the state of Oregon that is the plaintiff and the state of Oregon that is paying you?
That goes to separation of powers. The state of Oregon. If you'll allow me to finish, the state of Oregon is prosecuting you is the executive branch. The state of Oregon is paying you is the judicial branch. They are separate branches.
Hold on.
They are not. Well, let's put it this way: the state of Oregon judicial branch has confidentiality rules that apply to them. So, for example, I'll give you a simple example. I have cases in which it may or may not be helpful to a client to, say, undergo a polygraph examination. I am required to request funding from Office of Public service. No, I'm going to wait, because what I'm trying to say is the existence of that request for the polygraph, the fact that the polygraph may or may not have occurred, is matters which the state of Oregon, in the form of the prosecutors, never even find out about. The confidentiality rules, they're separate funnels. There's a Chinese firewall. See, there's no communication between those entities. And so that's what I mean. So you could try to suggest somehow, because the state government funds the Office of Defense Services by funding, that therefore I would work for the prosecution. Some people do make that confusion. It's not the case. Okay, so be clear about that.
So to
It's
clarify,
obvious the case does.
for example, what it sounds to me like, for example, if it were Walmart that was the plaintiff, it sounds to me as though the electronic section of Walmart is the plaintiff, and then the home and garden section of Walmart is the one paying the person who is supposed to help them.
No.
So, okay, how is that different?
Well, because first of all, there's no Chinese firewall between sections. There's no separation of powers within Walmart.
How do we know? They could institute policies that say electronic section, when they're doing this, they are not allowed to communicate with home and garden. But as far as I'm concerned, that is irrelevant because they are both Walmart.
Well, okay, but it's a false analogy. I don't care whether you think about it. Because Walmart is not subject to constitutional separation of powers rules. Walmart is not,
It's an analogy, sir. It's an analogy. You're missing the spirit of it to nitpick the details that don't matter. Those details aren't relevant. It's the analogy.
They're not comparable. I said because it's a false analogy.
And in what way? So you're saying that a 250-year-old document, a religious artifact, is the only difference that is making the change between analogies?
That's your authority. That's your authority.
I'm saying one of these things is not like the other.
I'm not communicating. Then is that because of the existence of a 250-year-old religious artifact?
It's not a religious artifact.
And what is it?
It's a social compact.
Does it align with all the rules of contract?
I don't know why you're asking.
Is it signed? Is it signed? Is it sealed? Is it delivered? Is there any consent? You know exactly what he's talking about.
It was ratified by the states. That's what you mean.
Well, if that's what I meant, that's what I would have said. So obviously that's not what I meant, but you can try and dodge it if you want.
The rules of private contract don't have anything to do with the rules of social compact, except to the extent that they choose to adopt them.
So
the Constitution has been ratified. If you want to suggest that the Constitution is somehow invalid or not,
do you want to suggest that getting it ratified by a bunch of elite white slave owners over 200 years ago somehow means it applies to put me in a cage and fine me of these U.S. dollars here today in 2016? We understand that's your religion. Good luck with that going forward. Just keep sticking to that, sir. It's going to serve you well. Keep going.
Actually, no. Actually, not in this case. The only person that is subject to those penalties is Robbie here.
We're talking about you defining law and going to the Constitution. Robbie didn't have anything to do with that.
I'm not inclined to try to define law.
But you'll use the word against him in justifying threats of violence against him. You're a deacon in their church obeying the Pope. We know what's going on. This is just circular. You're not exhibiting a good faith effort of anything. You're just defending the state. Some criminal defense attorney. What criminal defense attorney defends the state and its impositions upon people without evidence of the ability to do so?
Okay, all right, thank you, Joe. What are you reading from? This is Black's Law Dictionary's definition of law. Law, that which is laid down, ordained, or established. A rule or method according to which phenomena or actions coexist or follow each other. Law, in its generic sense, is a body of rules of action or conduct prescribed by controlling authority and having binding legal force. That which must be obeyed and followed by citizens subject to sanctions or legal consequences. Is a law. Law is a solemn expression of the will of the supreme power of the state. In Old English jurisprudence, law is used to signify an oath or the privilege of being sworn, as in the phrases to wage one's law or to lose one's law, as in Old English, not the law.
Sir, you're citing...
The term is also used in opposition to fact. Thus, questions of law are to be decided by the court, while it is the province of the jury to resolve questions of fact. The word may mean or embrace, body of principles, standards and rules promulgated by government, statute or enactment of legislative body, administrative agency rules and regulations, judicial decisions, judgments or decrees, municipal ordinances, science or system of principles or rules of human conduct.
And more opinions from the 1800s. Do you think we're playing this game challenging very powerful people without knowing where Black's Law Dictionary came from exactly and why it was created? Are you really citing that as some kind of authority as to a definition that we're supposed to, give respect to? Black's Law Dictionary is what confuses and manipulates, and it was designed to do that, all of the masses of the people who don't know this little magical system you have law, so that they could be imposed upon and stolen from, and imprisoned in enslavement-like conditions. And you cite the Black's Law Dictionary in this phone call for something that Robbie should take as advice?
It was not my choice to have this phone call, sir. I am doing that.
It's not about the phone call. You went to there to define law. Stop avoiding the issue on the table. You went there to define law as an authority.
That is not a factual definition of law.
There's no such thing as a factual definition. So definitions are not facts.
How about international maxims of law over thousands of years? Black's Law Dictionary has nothing to do with anything outside of this country.
Definitions are descriptions of meaning. Meanings have various degrees of precision. Some things are more precise than other things. Okay, so for example, the definition of hydrogen chloride.
This is lawyering to the best.
Than say the definition of love. Okay, so you see that definitions range in their precision based upon the sort of thing we're talking about. Okay.
So I would like a definition that is not written for the purpose of the game that is being played, and I would like to say,
well, all I can provide you are the definitions that are extant. We have definitions from legal dictionaries. We have definitions from non-legal dictionaries.
Again, just the actual evidence that the Criminal Code of Oregon applies to me, and this can all get resolved very easily if you show factual evidence.
Well, actually, it's going to be resolved whether or not you recognize Criminal Code applies.
Oh, here comes some intimidation.
It will be clear to you at some point that the Criminal Code applies to you.
Oh, they're going to win, Robbie. That's a threat of intimidation. Ooh, scare us. Please scare us, Mr. Scary Lawyer from Harvard.
Well, whatever.
You can tell the prosecution...
The portion of the definition that applies that which must be obeyed and followed by citizens subject to sanctions or legal consequences.
Okay, what evidence do you have that I am this thing called a citizen?
Well, I don't know whether you're a citizen, but I know that...
Is there any factual evidence that I am a citizen?
Do you think that non-citizens are subject to the law in the state of Oregon?
I
don't know if people think that, but
another distraction. Another meaningless distraction.
First off, I'll tell you how. You want to answer your question? How would you know?
How would I know?
How would you know that non-citizens are subject to the law of the state of Oregon?
That's not what I'm asking.
Okay,
violent force. Violence.
Okay, well, let's hear it.
Violence.
I asked, how would one know if they are a citizen, first off? Also, you just said, according to whatever definition that you read, that the law has to do with citizens having to follow laws. So I want to know what factual evidence is there that I am even a citizen.
Well, first of all, you're getting this generalized...
Just answer the question for once. Just for one time, just answer it.
First of all, definition, as I said, definitions of terms are more or less precise depending on the nature of the term. Again, we'll contrast hydrogen chloride as well.
Say there is no factual evidence that the Criminal Code of Oregon applies.
I'm saying there's no factual evidence required.
I'm not asking you.
Jesus.
I'm saying, is there factual evidence that Criminal Code of Oregon applies to me, yes or no?
Yes.
Okay, why?
The evidence is if there is practical evidence.
Okay, now I asked for factual evidence. Okay. So would you like to amend your answer, or would you like to stick with the
I will say that your question requires, your question is of the have you stopped beating your wife nature.
No, it is not.
No, it is
Here
not.
we go again. We can't use analogies. They don't make sense, but he can use them all day long.
No, the analogy about Walmart, you can use any analogy you want, but your analogies are subject to
Again, you nitpicked the irrelevant sideshow about that analogy and chose to focus on that when you knew excuse my language, you knew well what the main point of it was. Sorry about that.
No, I knew what the main point of it was. It was to attempt to make a false comparison between the separation, the separate powers of various branches of government, and the departments of a department store.
You're yet to prove that it is false, so you have no right to use the term false unless you prove
It's my opinion that it's false.
Okay.
Prove it it's not. You made the analogy.
We just transferred the burden of proof. Prove it's not.
We have State of Oregon, and we have State of Oregon. Okay? Again, there's no difference between Walmart and State of Oregon. There's no difference. Stop. Don't interrupt.
You will.
Okay, what is the difference?
The difference is State of Oregon is subject to specific laws and rules and practices, such as the separation of powers.
And where do those laws and
They derive from the Constitution of the State of Oregon.
okay, and what does any of that have to do with me?
You are present in the State of Oregon. This is you, right? The person that
This is a slave.
You're talking.
We're talking to a slave.
And talking in my office.
This is a room.
We're talking in a room, okay? And that room is located on the corner of 11th Avenue and Southwest Taylor Street.
Okay, again, I know it's irrelevant.
Well, I'm trying to tell you.
So at what point, I just want to know, at what point are you going to start talking about legal fiction and go away from actual...
I am stating facts, and because that seems to be, we have to keep things very concrete for some reason. So that this corner is within the city limits of the city of Portland.
Okay,
which is
the city limits thing. Is that a legal opinion or is that a factual thing that actually exists?
there. Well, if you walk out to the city limits, you'll see a sign that defines them.
How is that relevant to...
I'll tell you now, if you allow me to finish. So because I think I have to spell this out for you.
I can write a sign that says city limit on your wall, and so I
have the authority.
Okay, again,
It has to do with legal authority.
okay.
The authority comes from...
You exist within a place. You exist in a space, in a physical space. The factual evidence in this case that proves jurisdiction is this.
I'm not asking about jurisdiction.
We prove that you're subject to the criminal law of the state of Oregon. Is that what you're asking?
No. Robbie, he said this many times, that the court doesn't have to submit evidence of jurisdiction. If that's true, why don't the judges say that?
Well, because
Through 2 courthouses and 10 months and 10 hearings and their obvious embarrassment, why don't the judges just say that? We don't have to. Sorry, push them through.
Well, they don't have. Okay, look, they don't have to present that. They have to present evidence of each and every element of the charge at the time of trial, if the matter goes to trial.
Is jurisdiction an element?
And so jurisdiction. Okay, so here's where jurisdiction is alleged.
Oh God, here it comes.
Okay. Jurisdiction is alleged right here. It says State of Oregon, right? Okay.
Now, how that is.
I'm trying to get out. Maybe if I'm allowed to explain. Okay. So the said defendant, Robert Earl Estabrook, on or about February 28, 2016, in the county of Multnomah, state of Oregon, did unlawfully and intentionally refuse to obey a lawful order by a person known by defendant to be a peace officer, contrary to the statutes in such cases made, and providing against the dignity of the state of Oregon. So, now,
are we talking about the legal fiction state of Oregon? There's so much in here that...
Knowingly, intelligently is a lie.
If you'll allow me, now let's not be insulting.
I said I meant intent. I meant intentionally, not intelligently. My mistake.
Well, yeah, there you go. Anyway, so it is true that the state, in order to prosecute you, they have to prove each and every material element. Now, interestingly, it used to be until recently that they would have to prove that the acts took place in the county of Multnomah. That's called venue, as opposed to jurisdiction. Jurisdiction is the state of Oregon aspect. Okay, so and interestingly, and this is, and I would tend to agree with you that this is a true peculiarity. The appellate courts have recently ruled that the state. The prosecution no longer has to prove venue. Okay, and I think that's bizarre, and most of my colleagues agree. However, it is certainly true that in order to subject you ultimately, I mean, mean, at the end, so you may challenge jurisdiction, but the appropriate forum for the challenge to jurisdiction is in fact the trial court. See? You're saying, oh, you know, there's no proof of jurisdiction.
Sir,
well, no. So the evidence, no, I'm not quite. The evidence of jurisdiction would be the statement of some sworn individual, a police officer or whatever witness, right, who would say, you know, and they would ask, did this occur within the county of Multnomah and state of Oregon? And they would say yes.
Okay, why won't the judge just say that? Back to the question, why won't the judge just say, because evidence of jurisdiction isn't required? Please answer that. That's where this was going. Please get back to it.
Evidence of jurisdiction would be provided at trial.
I asked you, why won't the judge say that? Why won't the judge say that?
Well, maybe they just think it's a stupid question, or maybe they haven't, you know, really thought it out. I mean, I could certainly...
Through 10 hearings... 10 hearings and like 5 judges in 10 months, they just maybe just didn't think it out.
Let me ask you this.
Okay, no, we're not switching. This is still on the table until it's resolved, sir. That's how civil discourse works.
I'm trying. Okay, well, let's suppose that occurs. Let's suppose you go back to court and the judge simply says, well, because they're not going to call you Robbie. They're going to say, well, Mr. Estabrook. Well, they're going to say, do I have to refer to somebody using my incorrect name? Well, whatever. I'm asking you because I want to ensure my safety and I don't want to be yelled at and threatened by people anymore. Oh, well, okay. Well, if they call you Mr. Eastbrook, obviously you can just... Again, I am asking you, what obligation do I have to respond to somebody who is using my incorrect name? What, Mr. Estabrook? Yeah. Well, do you have identification? Right. I'm asking this.
Trying to paint you as a crazy person. Just another BS tactic.
Driver's license or state issued ID. I have several things. Right. They don't all just say Robbie.
They're state issued. There are opponent issued. Minor detail. Oh yeah. Oops. Forgot that part.
What about the ones that aren't issued by the state? I mean, like a rewards card.
Again, that's voluntary. If I want to go to college and give them a name for them to put on an ID so they can track me, that's their prerogative.
So let me finish here. What I'm saying is, when you get mail at home, you know, whatever, my guess is it probably has whatever you will. Well, yeah, and I probably will. When if you live somewhere and you signed a rental contract, you didn't just write Robbie, and the landlord didn't just write Robbie. My guess is it says Estabrook. It's your name. Estabrook is your name. You're making and I'm right too. No,
do we get to choose our name, or do you get to?
I have a rental agreement, and it doesn't have the name Estabrook. Of course not, because that is not my name. Yes, I'm not. The name was given. I'm not disclosing my personal details of voluntary agreements that I have. I don't have to do that. I'm asking you, what obligation do I have to respond to somebody who is using an incorrect name? Well, don't respond to this. What do you mean? Don't respond. Don't try that again. See how it goes for you. So are you trying to dodge?
That's his advice. See how it goes for you.
Are you trying to endanger my life? No, I'm not. You've just given me advice which would endanger my life.
We have evidence for that, too. Be careful where you tread. This is bigger than you think. Otherwise, why would they put Harvard 20 years of experience on something that's pled down to 8 hours of community service?
I already told you because I happened to be the pickup attorney that day.
Well, I'm sure. We're just going to believe that one.
Well, it's true. You can
well, then either you're not what you say your credentials are, or you're just not very good at what you do, because people who went to Harvard and 20 years of experience don't spend time on people like Robbie for these charges. Sorry.
Well, there's where you're wrong. There's where your assumption is wrong, and I will grant you that most of my class.
I'm wrong that you're not a very good lawyer. That's not up for you to determine. That's for your clients to determine. And based on this visit so far, you're telling him to just go with it and hope for the best. Good advice.
I didn't say make the kind. I just said if you really doubt the court's authority to call you by your surname.
I doubt the court's authority to rule my body. This is my flesh and blood. I determine what my name is, not the court. Period. Get used to that concept.
Well, I don't even know if I'm a defendant here. You're the name defendant. Okay, what name is on the? It means that your name is on the charging letter or not. Robert Earl Westerberg.
That is not my name.
Well, it was when you were born.
No, it wasn't.
I guarantee it.
No, it wasn't.
Okay.
How can you guarantee something like that?
And what choice did he have in that matter? His parents gave it to him. That's going to impose upon him. Your logic is flawed to the nth degree, and you know it. It's not working. If you want to do us a favor, go to the prosecutor and tell him that this kind of treatment is just going to continue and continue online to embarrass every single last one of them. It's going to make their full real names searchable on YouTube forever for their kids, their parents, and their siblings. They can dismiss this case and this will all go away, or they can keep going on and get more of the same. But you're getting a tiny picture of what's to come.
I'm on the phone with somebody now. Hold on. So I just want to clarify that you are telling me that if I am referred to by a name that is not my own, that I should go ahead and not respond to it and see what happens.
No, I don't think you should. What I think you should do is, if in fact the court refers you to you by something that is not your true legal name.
No, I'm not asking about like quote unquote true legal name.
That's the only thing they're required to refer you to.
Again, you're talking about opinions and I'm talking about facts.
No,
so I want to know what obligation do I have to respond to somebody who calls me by the incorrect name? That's all I want to know.
Okay. So, well, and let me answer the question. First of all, it depends on who it is. Right? In other words, you are under no obligation if someone on the street, or someone else.
Okay, well, I'm not talking about that situation.
Okay, we're talking about what obligation do you have to respond to a judge?
By a person calling themselves a judge, by calling me a name that is not my own.
And it's not your own based on what?
Okay, if I call you George and say, hey George, this is your name, and this is what we are deciding your name is, and now I'm going to hold a gun to your head and tell you what you have to do now, George.
Well, actually, no, the problem with that, I would be able to pull out my birth certificate, have my legal name on it.
Oh, I'm sorry, I don't recognize that. I'm sorry, but no, according to our documents, you're just George.
Yeah, okay, but here's the problem. You can't pull out a birth certificate that says you're not Robert Earl Westerberg.
Again.
Why can you?
Yeah. Exactly. That's the document that establishes your natural birth and your legal name.
What does so-called birth certificate have anything to do with me?
It has to do with you because you, like everybody else, get a name at birth.
Okay, so you're
get a name
to impose.
You're saying that everyone else
you just
gets a name at birth, and that is everyone on this planet gets a name, and they all have.
I don't know about other countries in the United States.
Okay, well, I'm talking about in fact.
I'm talking about in fact in every individual born in the United States. Okay, because I don't know what they do in Sweden.
And my name given to you is Robbie.
Okay, so your legal name is Robbie.
Again, I don't know what a legal name is.
I'm trying to tell you what it is.
Okay, well, again, I don't care what the legal opinions are. All I'm asking is, what obligation do I have to respond to somebody that is calling me by a name that is not my own?
Okay, well, first of all, you're operating under the premise that that's not the name.
Who knows best what our name is, us or you?
That is not my name.
Okay, you're operating under the premise that that's not the name.
Of course it's not. So you like George isn't your name.
Well, no, but I can prove that it is my name. Prove that Robert Earl Westerberg.
I don't have to prove it.
Yes, you do.
No, my name is Robbie.
Transfer the burden of proof.
No,
you don't have. You can though. The point is, I can prove what my legal name is.
Good for you.
I'm talking about the name.
The court is talking about legal.
Okay, so why is the court true? What authority? What is factual evidence that the court has the authority to impose this so-called legal name upon me? By whom?
Your parents.
So we're to be imposed upon by what they say. Nice.
I suppose I could apply for a copy of your birth certificate. Or, you see, here's the problem. If you're the one claiming that that's not your name, the burden is on you to prove this is your name.
No, because I'm not the one that is being held against. I'm the one being held against my will. I'm not the one forcing you into playing a game. I'm not the one holding a gun to your head and putting your liberty on the line. So again, you have the burden of proof.
Okay, well, if you can establish that you're not Robert Earl Westerberg, great. Otherwise, you're Robert Earl Westerberg.
Obviously, I am only Robbie.
So it's not obvious to anyone.
Well, it is.
Every person in this country, United States of America.
Okay, and when you have a person like the United States of America exists,
we have ranged on into the realm of delusion.
No, we have not. I'm asking you for factual evidence again. Again, if anybody here is delusional, it is you, because you are relying upon opinion to say that the United States of America exists, and I'm asking you for factual evidence. Keep in mind, I am asking you to provide factual evidence that the United States of America exists, right? If it was so easy to prove in fact, then you would just simply do it. And if I were the delusional one, then you would obviously have evidence. But do you have factual evidence that the United States of America exists, yes or no?
Yes. It's obvious that the United States are.
Okay, obvious. What is the factual evidence?
I have a passport.
Factual evidence.
What is it? What's the factual evidence?
Okay, this is crazy talk. No, it's not. Yeah, it is for factual evidence.
Yeah, I'm not
factual evidence you have
to attempt to prove the existence of something. So
He's taking that out.
Yeah.
That's a weak out, and he took it.
It's just I'm not playing this stupid game. We're not playing this stupid game. I'm asking you for factual evidence.
I have been here for 2 hours.
And well, I apologize. I was waiting for you for like an hour. Okay, and I have relevant clarifications. You're paid by the hour. You specifically told me that we would not be rushed.
We're not getting anywhere.
We are getting, and I do have to get something. Well, so in order to be self-paid for it.
No, you won't.
Yeah,
no, I've got my own food here. So heat it up and eat it as we're done.
Go ahead and heat it up.
I will eat it when we're done.
So
I'm not going to attempt to prove the existence of the United States.
But you would then just simply prove with factual evidence that those ORS statute things apply to me, please. Show me the evidence, since it is currently your duty to inform me of the cause and nature of the previous stuff. I just want a yes or no. Is there factual evidence that the Criminal Code of Oregon applies to me? Just say yes or no is all I'm asking.
The factual evidence the Criminal Code applies to you is observable. Okay?
Explain
Because they have guns.
Observable factual evidence is.
The guns are the fact. The
Call
police.
it the coercive power of the state. Call it what you will. Okay?
We want to know what you call it, not what we call it.
I call it the jurisdiction of the state of Oregon, or the in personam jurisdiction of the state of Oregon over persons residing or present within the state.
So the jurisdiction of the party that's named as the plaintiff in this ordeal is what you're relying upon.
Call it what you will, yeah.
No, I'm not calling it that. They're calling it that. It's their paper, their orders. They put State of Oregon versus Robbie. You just relied on the authority of the opponent, and you're a best criminal defense attorney with lots of experience. That's terrifying.
Well, I'm sorry you see it that way.
I just want to clarify, for my own understanding, you're saying that because there is a gang of thugs with guns that are forcing me to follow the rules that they wrote down in some book, that is the factual evidence that the Criminal Code of Oregon applies, yes or no? Well, is that your...
Not exactly.
Not exactly.
Where I am off.
But because this particular gang of thugs, if you will, has the implicit consent of the people.
Okay, and can you explain to me how they acquired this implicit consent of the people and who the people are?
Originally, they did so.
I would like to know who the people are right now and how they have the implicit consent of these people right now.
Okay, well,
am I one of them?
If you vote, you are.
Okay.
Voting, oh God.
Yeah.
Jesus.
You're not a law unto yourself.
Am I a part of the so-called people?
A very small part.
Yes or no? Am I a part of the people?
A very small part.
Am I the people?
You're not. No, you're not the people.
Okay.
The people is a collective. It's not an individual.
Am I a part of the people?
One portion.
So you're saying yes?
One portion.
Is it a yes or no? Am I a part of the people?
And the answer is a very small part.
Okay, so it sounds like a yes.
No, is that a not an unqualified yes?
Fine. It's a yes with an explanation. A very small part. It's still a yes.
But the people is a collective. It's not one individual.
You can't even...
You are a person. You are not the people.
Yes.
The answer is no.
Am I a part? So I'm not
You're a person. You're a person.
Clarify.
I deny
the answer
that.
is no. It's not a part of the...
You are not the people.
I am not a part of the pure one individual. Am I a part of the pure part? Yeah, I don't know. So I am a part of it. Yeah. Thank you. So where the hell are you going with that? Does that mean the law doesn't apply to you? Because you're part of the people? Hold on. How about you let me write down what we just said? Yeah, well, what difference it makes? Kind of obvious.
Now, there's a good question.
Because I fail to see the invisible things that you see. So you see invisible things. I see the things that actually manifest themselves in the universe. Okay? So you can make up your opinion as much as you would like, but I see what exists in fact. So you have said that I am a part of the people.
Yes.
Okay.
You have a right to vote.
And again, I fail to see the relevance of voting.
Has nothing to do with it.
That's where the authority of the government derives from.
Borrowed, false authority, unethical, illogical. Voting has nothing to do with it. Let's keep voting off the table, please. Thank you.
No, yeah, I get to decide. It's my table.
Well, again, you're not the one whose liberty is at stake here.
It's the table.
In the fact that you're not part of a criminal investigation. Okay. What do you mean?
Who's going to enforce these particular criminal investigations?
Oh, now we're getting to the guns. It is men with guns.
They got the authority to arrest you?
Yeah, the men with guns.
Who will enforce the crimes that you are committing?
Yeah, I might be.
If you choose to commit crimes,
well, I'm just trying my best to keep my patients in a ludicrous and madcap environment.
Okay, we think it's ludicrous too, so stop saying that. We all know we think each other is ludicrous. Acknowledged. Move on.
How is it ludicrous to ask for factual evidence?
Factual evidence of the fact that the government has the authority to enforce its criminal laws is ludicrous.
I am asking not that question. I am asking, is there factual evidence, yes or no, that the ORN that you are alleging applies to me? Is there factual evidence that those apply to me, yes or no?
To the extent that you were arrested within the territorial borders of the state of Oregon at the Portland Airport, it looks like.
So you're saying that the factual evidence that those statutes apply to me is the fact that a gang of armed people kidnapped me and threw me in a cell.
Well, no, more specifically, it's the fact that that gang of armed people kidnapped you and threw you in a cell within the confines of the borders of the state of Oregon. So, in other words, has this occurred in Mexico City? And had this occurred in Mexico City's airport, then no, the state of Oregon wouldn't have any jurisdiction.
Ludicrous.
No, you talked about borders and being within. Borders are up there now. How are they at that?
Because you can step over them and across them.
Okay. Do they exist?
Their opinions.
And can you?
They exist pursuant to the fact that we agree they exist.
Who agrees?
You.
Most people.
Most.
Again, don't commit the logical fallacy of appealing to authority and tradition. I want to know.
Merely authority. It's agreement.
Again,
there's no consent.
Agreement because you and your religion people, all of you religious people, have this agreement. Just like the Catholic Church has their ideas, the Mormon Church has their ideas. They can feel free to the Mormon Church can feel free to prosecute its members for whatever rules the Mormons break in that church. But if the Mormon Church tried to come to me and say, hey, looks like you had sex out of marriage, now we're going to punish you, I'm going to ask them, what factual evidence do you have that your rule applies to me because I'm not even a member of the church?
That's the difference between a religion and a government.
Well, again,
government
name only. And name only today.
Irrespective of, everyone within the jurisdiction of the government, which in this case is a physical.
So is it everyone, or is it everyone within the jurisdiction of the government?
Everyone equally.
Okay. So are you saying that the Criminal Code of Oregon and the Oregon Revised Statutes, whatever you want to call them, are you saying that those apply to everyone?
Everyone within the physical confines of the state of Oregon.
And what actual evidence do you have that those rules apply to me just because I'm physically located in some geographical area?
The fact So remember we distinguished between fact and law? The law is.
We tried to clarify what the law was, and you got angry at us for it. You're the one introducing the word, and we're trying to clarify what you mean. We're not going down this rabbit hole again, sir. You already went down this rabbit hole. We're not going to stand by and let you do it again.
The law is defining law, please. We already did that. Okay, no. That is Black's Law Dictionary. That is opinion. I'm asking for definitions. No, that is Black's Law Dictionary. Those are legal opinions.
Written by a fool and a...
Follows like a person subject to the sanctions or legal...
A person or citizen? I'm saying person. Okay. And in the state of Oregon, what is a person?
Lawyer person.
How do you know?
If I can see you and hear you and talk to you and ask a question and get an answer, however dodgy.
Is a person a physical human? Is a dog a person? Okay.
So a corporation is a person. But
Whoa. Okay, well, can you see a corporation?
They're a person, but because the law says they're a person.
Okay, so again,
The law.
now, first off, saying you know that I'm a person because you can see me.
Yes.
So, but you're saying that you can't see a corporation. Right. Yet a corporation is a person. So would you please? They're different standards of proof. Okay, so you're saying that one thing is a person and we can apply standards of proof for that person, but then another thing is also a person, same thing as that person, but we're not going to apply the standards of proof.
Yeah, exactly.
So again, there is no factual evidence that I'm a person.
Okay, well, pretend you're not a person.
No, I'm not saying I'll pretend that I am not a person. I'm asking, do you have factual evidence that I am a person? What is it? Okay, and if there is a corporation in here, can you see that with your eyes and ears?
No, that's different level of proof. That's what we refer to as a legal fish.
Okay, so I don't know whether or not you are speaking to me as a person in the sense of a legal fiction, or if you're speaking of me as a person in the sense of a factual thing.
Well, but
if you're going to apply a definition of law, stop. You're just making a fucking fool of yourself.
No, I've been making a fool of myself by bothering with you all this time, but I'm still doing it.
No, I'm asking you for factual evidence that you're a person.
That's pretty damn silly, isn't it?
No, it is not.
The 14th Amendment isn't silly.
That's dictionary.
No, I'm not actually. I'm not.
I'm a person according to whatever that Black's Law.
You're whatever you want to call yourself. Good luck with this. Okay, look, what you are just right now is done.
He's quitting. He's the one calling the shots here. Woo!
Do you have factual evidence of these things apply? What plea?
Once they're going to throw you out if you don't get out.
So you're threatening me with violence? I'm asking you to leave. No, you're threatening me with violence.
That's a threat.
No. You just threatened me. No, I asked you to leave.
Harvard, 20 years. Can't handle the heat of Robbie. Go ahead.
Okay, so now you're threatening me. Okay, so are you going to continue being legal advisor? Okay, so I still have things that I need to let you know that you need to be prepared for the next meeting. Okay, so first off, what I need to know is I need an affidavit to the judge that you have just threatened me and told me to leave because I'm asking for factual evidence. I don't know your email. On my card. I don't have your card. I gave you my card. No, you didn't. Okay, I need good day. That was fun.
Man, I just let you take over because, dude, you were crushing it.
Yeah, sorry about that. I just kind of got into it and couldn't stop.
A fucking fool. Oh God, Robbie, that was so much fun. Okay, hold on. Let me hit save on this. Oh my God, Robbie.